sustainable development.
Speaking, we have the chief of the committee and member of the Bar Association Council in Russia, Dr. Anastasia Milutina. As a speaker and moderator of this panel, we have the vice president of the National Human Rights Commission for the Federal Bar Council, Dr. Fernanda Brandão. And to lead the conversations, we now give the floor to Dr. Fernanda Brandão. Doctor, the floor is yours. Good morning, everybody. Thank you very much. Pleasure to have you here, even though it's a sunny Saturday outside in the wonderful city of Rio de Janeiro. Let us start our work. I wish you all a warm welcome to my colleague and Anastasia as well, who will start her presentation soon, and then I will do my panel. I declare the second day open and give the floor to Dr. Anastasia.
Уважаемые коллеги, доброе утро. Благодарю за предоставленное слово.
Dear colleagues, good morning. I thank you very much. Thank the Brazilian Bar Association for organizing this 10th Legal Forum of BRICS. And I greet everyone in this plenary meeting. A very important question was raised with the cooperation of our countries to achieve these sustainable development goals. Every country has their work done in this forum, trying to find the association of legalists in Russia is the largest bar association in Brazil, in Russia, and also the SDGs of the UN are some of the goals that we must achieve. We created a commission with different agencies and representatives of private sector, banks, investors, academia representatives as well. And just general public people, we coordinate the work between the legal sector and the private sector representatives in the BRICS country. Yesterday, Tatiana Moskalkova, one of the representatives of human rights along with the Russian presidency, highlighted the serious human rights situation in the whole world, with embargoes to medication and other very necessary goods to vulnerable populations. And such, we had the need of a public support against these sanctions, like the sanctions that are being applied on Russia, which worsened the life not only of Russian citizens, but also of other countries who applied these sanctions. Furthermore, several topics, like, for example, taxes over greenhouse gas emissions, are being used as political tools, which helps the European Union to defend their own markets, but is some kind of green protectionism and pressure on developing countries to support these humanitarian projects. And the legal community must mobilize. We must not only support them in ESG, but also must embrace sustainability, which already exists in the legal area. We have many companies who also work in the SDGs, and we continue to develop this in the legal community within BRICS. We also must discuss not just big companies, but also small and medium companies. And the contribution of small and medium enterprises are very important for the economy of the countries, and it takes several projects at an international levels that allow the populations to have access to resources locally. It is also important to pay attention to the destructive role of unilateral sanctions for the hegemonic countries to try to stall the development of developing countries. This has been discussed during the summit of the BRICS in Rio de Janeiro this year, and also the leaders meeting on September 8th. I firmly believe that our work group could contribute greatly also to overcome this hurdle. We should insist on the supremacy of international law over the ambitions of other countries like and organizations like the EU, contemplating the particularities of every country's, and also paying attention to food security and energy security in the world. Another important vector in our work could be the training of certain legal professions on ESG to create consultancy as well as methodologies and theoretical material to support investors or even copyright issues and others. We are also open for dialogue with you and to work in conjunction with you. Today, the economic systems in the BRICS countries are extremely influential in the world. Ecology is a global issue, and it is very necessary to work in that direction, regardless of sanctions and individual perspectives of each country. Today, we can evaluate investments, especially legal investments in ESG, like a strategic sector that it will be for us. I think that this will lead to the increase of cooperations in the human, economic, and other sectors. Thank you for your attention. I'm open for questions and other discussions.
Muito obrigada.
Thank you very much for your presentation, Dr. Anastasia. I was able to see that we have in common the fact that we are here in this panel today representing the largest law-based entities in our respective countries. We also have in common the fact that our institutions are favorably positioned towards the democratic state of law, which absolutely brings us together beyond this joint participation in BRICS. We are sure that we could think about activities, and we will be extremely well represented by Dr. Francisco Caputo, Dr. Bruno Barata, Dr. Argaya, to jointly work in name of our institution, always considering, and we also agree in this topic, in the supremacy, national supremacy of our countries, and to be attentive for these human rights issues so that they are not used in a veiled manner as a excuse for tax sanctions. So this is a concern that we have. I'm going to start now my presentation. Thank you very much for yours.
Bom dia a todos e a todas.
Good morning, everyone. I thank you in the name of Beto Simonetti and Dr. Bruno Barata the opportunity to talk to you all about this very dear topic to me, which is as a vice president of the Human Rights Council in the Bar Association. I could start discussing several aspects of the role of the state in promoting sustainable development, or even the role of companies to promote sustainable development. But I decided to use this opportunity, considering what was debated yesterday, as well as the public that we have here, a very distinguished array of attorneys from different countries, to discuss the role of civil society for sustainable development specifically. Now, so that we are all on the same page, we're going to discuss sustainable development on three perspectives. We're going to talk about the social dimension, a environmental dimension, and then an economic dimension. Here, I opted to discuss specifically about civil society. Obviously, we could talk about the role of consumers, choosing products. We could talk about other entities that are as relevant as the Brazilian Bar Association. But because I am a member, I decided to discuss the role of the Bar Association in Brazil, the OAB, to promote sustainable development. And that's why I'm going to divide my presentation in three different sections about the Bar Association doing internal corporeal participation, what we do internally and affects us as attorneys, what we have done judicially, and what the bar has done internationally. Here, the main idea is a good practice sort of list so that the colleagues here who honor us with their presence could think and use, and whatever they think is useful, some of the measures that we have already taken. An initial highlight is that our institution has 1.5 million attorneys registered, which is a significant number, and many people congratulated Beto Simonetti, our president, because of the political context and the way he was able to get reelected and how he handles and spearheads all of the work. In a continental dimension country like Brazil, we also have a huge number of attorneys, which brings us some diversity issues. So a first major milestone that I would mention is the resolution number 5 from 2020 of the OAB Federal Council, which instituted gender equality as well as racial nomination quota, which means that from this resolution onwards, every one of our institutions, the directors as well as the sectional councils, each state necessarily must have 50% female employees as well as 30% racial nominations. This is a huge advancement because from such resolutions, women like me are able to be here today. We proclaimed ourselves sort of daughters of equality, and when this opportunity is opened, we also start thinking about a public of women who are most of our attorneys today. And before this resolution, even though we were the majority in Brazil, we didn't have this practical representation. From it onwards, we started having it. So each state on our federation has their own members, of 3 men and 3 women. In the sectional councils, we have half men and half women. Also, within the interna corporis dimension, I would like to highlight some of our registers, which are like consolidated precedents in a way within our system.
We have Precedent 6 of 2018, which sets forth the concept of moral trustworthiness, which provides that the lawyer that here in Brazil will have a peculiarity. We have the bar exam. The lawyer spends 5 years in the college, in the law school, so he has to pass the bar. After passing the bar, the lawyer needs to meet some requirements, and these requirements we have that of moral trustworthiness. he has to be, they have to be suitable to be a lawyer in Brazil, a trustworthy person. Precedent 9 sets forth that people who have been charged, convicted for the crime of violence against women are not suitable to be a lawyer. They can't be a lawyer. They won't receive the lawyer card granted by the Brazilian Bar Association. Precedent 10 of 2019 prohibits the registration as a lawyer of people who have committed violence against child, teenagers, elderly, and disabled people. Precedent 11 of 2019 prohibits the registration of applicants who have committed violence against LGBTQI+. And this year, Precedent 13 was approved and prohibits lawyers who have committed, they can't be registered, those who have committed racial torts or racial offenses. This concretize the purpose of developing the sustainable development. We talk about equality between people. Besides, we have had the opportunity to see the recommendation on climate change based on reflections of COP26. It was recommended by the president, stating that the bar sections should participate in legislative process in their states on climate change topics. Besides, there is a recommendation for the law firms which have revenue above 10 million a year to promote pro bono activities to serve for free people, vulnerable people. And it's also recommended for law firm to achieve net zero by 2050. Initially, we talk about movements made regarding social issues, and now we are talking about environment issues. I would like to add that on the environment point of view on the sustainable development, I would like to bring here some things that the Superior Law School performs, which has offered several free courses for all the lawyers, including those who are in a vulnerability position, which I would say is a good practice. On the action of the Federal Council on the federal sphere, I will bring here the cases filed in the Supreme Court, which is our highest court. We are talking about the judicial reviews. We are talking about the Superior Court, talking about the actions for non-compliance, for breaching of fundamental rights, the ADPF 770, where the Brazilian Bar Association is the plaintiff on the context of COVID-19, that was stating that the municipalities and states, besides the federal government, should be able to import vaccines. Another institutions also adopted this measure, but it was after the action of the Brazilian Bar Association. Exceptionally, the Brazilian health, which is in hands of the federal government, the municipalities and states should also be taking care of it. The ADPF 885 was filed by the Federal Council of the Brazilian Bar Association on the omission of the Brazilian government fight against the hunger. We can see that in the federal sphere, it promotes the sustainable development, represents the whole society. And now the interests are not only towards the lawyers. And the judicial review ADIN 6069 in 2017, we had labor reform that changed our labor laws. And among those changes, one that was very important is the standardization of labor compensation. Basically, what the lawmaker did was to set forth the amounts that would be paid in case of compensation, that they would consider the light, mild, less severe, medium, and very severe and very severe. So it was preset an amount that should be paid to the injured laborers in case of labor relationship, of a labor relationship. After this labor amendment of the laws, we had the case of Brumadinho. I believe that you have heard about it. There was a dam rupture that caused the death of several workers. It was a social and environmental tragedy. And then the Brazilian Bar Association filed this judicial review, challenged the inconstitutionality of this labor reform. It couldn't be set beforehand because it could cause losses for the workers. So from this action, another entities have already filed this action, and then based on this action, the Supreme Court understood that the amount of the standardization amount for labor compensation serves to guide but not as the limit for paying. And it was headed by the Federal Council of the Bar Association. The APDF 973 and talk about the state of things of the structural racism inconstitutionality. It's the case of political parties. They filed this action with the Supreme Court, and the Brazilian Bar Association was the amicus curiae to follow. It had the opportunity to do the oral arguments. The president of the human rights of the Brazilian Bar Association stated that the way Brazilian is and treats this subject is unconstitutional. It provided for, among other measures, is the possibility of a repair for black people. And then we have the ADPF 1053, which was filed by the general attorney, the federal general attorney, that states that the labor could not be time barred. The federal council decided that all these cases go through a decision of the plenarium, and decided to be the amicus curiae and file a favorable statement on that labor should not be time barred. Now I have spoke about the measures that the Brazilian Bar Association has adopted internationally. I could highlight the participation in General Assembly's UN General Assembly's panels, in UN climate change conventions, in an important forum that we were represented. The event with the England Bar Association and the Court of the England. We participated in this event performed this year. The research project on law firms of and crime in partnership with the International Bar Association, and the importance in this forum, BRICS Legal Forum. I would like to give my final reflections, my final comments. I know that among our possibilities in between our institutions, respecting the culture of each country, individually we need to have hope and wish the best for our institutions and nations. So I bring here the speech of a very important Brazilian author, Ariano Suassuna, which says, "The optimist is a fool. The pessimist is annoying. It's really good to be a hopeful realist." I wish that we all can be this is hopeful realist. Thank you very much. My name is Vladimir Opatin. I'm the head of the intellectual property of Russia, intellectual property of Russia. I am the president of the Interstate Committee. Our community, our jurist community, is not self-sufficient. They need, I understand, not only to have progress in their career and increase the qualification of the lawyers and another jurists, they have to help to make the right choice. And I advise and bring with government agents and representatives of the private sector. I have a question regarding the topic of sustainable development. In 2024, UN rang the bells because the plan by 2030 it's not working. This plan, only 18% of the goals have had any progress. 35% are stopped, and they are below the level of 2015 when we start to talk about this topic in the UN. So I make a question in the national level in Brazil, in the Bar Association. We made it was made an analysis, the delays in the direction to meet these goals of sustainable development. I'll talk the Brazilian Constitution, the intellectual rights. In 2024, according to UN evaluation, the level of quality,
The level of regulation in the intellectual property sector lost 11 percentage points in a year. And that was a threat to guarantee the sovereignty and economic growth as well as this SDGs. So I wanted to ask you, coming from this perspective, is this written in the Brazilian Constitution? And the UN has seen a worsening of the regulation in Brazil in this specific area. Have you had any analysis on this in the Bar Association? If so, what was proposed from the government to improve this situation? I ask you because in Russia, this is also really important. Russia lost 27 points in this area, which could be something political, or it could be a situation that we need to perhaps discuss in conjunction. We raised this conversation in the 7th panel, and we will continue to talk about this after lunch. But in terms of the sustainable growth and sustainable development, I wanted to ask what your position is.
Bom, eu sou.
Well, I'm a former professor at the Federal University of Rio de Janeiro. I was a researcher in the Amazon forest. I did 8 botanics, 8 subjects of human biology. So I'm here as a representative of the International Red Cross, which is an institution that has the principles. And we created a partnership with the Rio de Janeiro Bar Association, but it also applies to the national level. So I'm here to try to sort of help answer this question, because I was also an expert for federal judges, and I think it's quite important to discuss the structure of the Bar Association in Brazil, but at the same time, the search for experts on areas of knowledge. These experts are all over engineering, medicine, biology. So you have an idea. In Rio de Janeiro, we have 4 medical academies. We have the National Medical Academy, the Rio de Janeiro Medical Academy. So there's a huge amount of professionals qualified to talk about these issues, to discuss health or biology. So I just wanted to add this, which is important for lawyers, is for them to try to find and provoke the demands of the expert opinions for each topic. Because in global warming, there's a lot of mixing. Sometimes you have experts that are in the atmospheric area don't understand anything about hydric resources. They're not also familiar with sustainable forestry, and that's why a lot of the times, because of the media, we focus a lot on catastrophic narratives. Yesterday, they said that the Copacabana beach is going to end because the sea level will rise, and that's a lie. We have solutions and strategies in terms of engineering to recover from any impacts. So let us not be as sort of apocalyptic, say, and stop with this idea of catastrophes. I'm sorry if I said too much, but I just wanted to sort of bring the experts into the discussions. I'm here as a guest. I'm not a lawyer, but I was in the CONAMA for 4 years. I hope I have clarified some things, or at least contributed to the conversation. Excellent presentations, by the way. Thank you. Thank you very much for your contributions, for your questions. I kind of didn't write the names, so I'm sorry for that. But with regards to the first question, I would say that individually, looking at the SDG perspective, we do not have a measure adopted by the Federal Council, especially because here in Brazil and in most countries, the SDGs have this soft law characteristic. So we apply them as an argument and not as a binding structure. So with regards to intellectual properties, more specifically, myself as a representative of human rights, I'm not perhaps the most adequate responder to your questions, because we have a specific commission, and I really don't know if anything has been adopted. But when we close out this panel, I'll try to find out about this information, because several times I talked about some other colleagues during my presentation who did different work, because a common characteristic of our institution is this decentralization. We're doing volunteer work consistently, so perhaps the colleagues who are leading international intellectual property might have adopted some measure that I am not familiar with. But with regards to the Human Rights Commission, measures have been adopted presenting argumentatively such data. For example, in the case of our the imprescribability or the break of the time limitation for the fulfillment of SDGs, especially considering the lower punishment level for this kind of crime in Brazil, and how it pertains to the human rights agenda. So I thank you very much, and now I give the floor to Dr. Anastasia for her final remarks before we close this panel. Thank you.
Да, коллеги, спасибо большое.
Dear colleagues, thank you very much. I think that this is a very important topic that we are discussing at the moment, and the questions and reports were excellent, and I think we can try to find answers in conjunction, because these are global problems, issues, and the solutions depend on all of us. So thank you very much for your attentions, and we're open for dialogue. Thank you very much. Well, with this, then, I close the first panel, thanking all of you for your presence. Thank you.
Em prosseguimento para
Continuing now, we are going to the fourth panel with the topic Inclusive Governance, Technology, and Access to Justice. We invite as a moderator Dr. Gaia Schneider. As speakers, the Vice Chief of the Execution Department for Legal Decisions of the Federal Service of Court Officials in Russia, Dr. Dmitry Yelukov. And then the Chief Advisor of the Department of Technology and Information of the Moscovian government, Dr. Yefi. And we invite the presidents of the member of the Presidium and the Bar Association in Russia, Dr. Konstantin Korsky. The former co-member of the Bar Association in India, Dr. Jai Prakash Gupta. We invite the Associated Professor on the International Law School for China, for Western China, Dr. Feishu Yang, and the Deputy Professor in Public Law in the Marsaid University in the Tehran, Dr. Syed Mohammed Mahdi Gamami. Please take your seats. And to lead this panel, we'll now give the floor to the moderator of this panel, Dr. Gaia Schneider. Hello, good morning, everyone. It is a great pleasure to be here with you today, where we congratulate all of the nations. We see so many women here today, which makes me very happy, especially in the Federal Council of the Brazilian Bar Association, whom I thank, especially in the person of President Beto Simonetti, because the bar would never miss this great event, which brings a lot of importance for the decisions made through this meeting of great nations. The topic under discussion today is extremely relevant. Governance in the era of AI is crucial so that we can discuss the evolution in ethics within the relations. We know that they are in favor of humans and they need to serve us, not we need to serve them. So it is really important to hear researchers present here, especially in Russia and India and China, how important it is for us to hear them all so that we can always try to find the best way to use AI through corporate governance, and that we're able to, through AI, reduce inequalities. So getting all of these great energy that the Human Rights Panel brought us, and let us have excellent discussions.
So we'll begin talking about the digital rights and currencies. And I'll give the floor to the decision making, the Federal Vice Service, Dr. Dmitry. You have the floor. Thank you for being here. Welcome. Good afternoon, members attending the forum. I would like to thank you for the opportunity for attending this 10th forum, legal forum, BRICS legal forum. I would like to introduce myself. The digital is part of the daily life, and it increases efficiency in several processes. The digitalization changed everything in the financial market, in the economics. which has always been subject to change. The Federal Russian Federation, where a lot of change happen. New payment methods are created, and assets are digitalized, and digital currency coins and the Russian digitalization. The digital rights are a theme of civil rights, and it is also under the property law. There are rights with maintenance in accordance with the maintenance of digital services. So the Russian law understands digital rights, those that are reflected in the law. And I will talk about it from the Russian digitalization point of view. Another, other ways are not possible outside the information system. There are two types of rights, the and the right of use. The digital coin is not a digital right according to the Russian law. There are two laws that regulates the digital rights and the coins. It's a very very large names. I'll give you here. There are some laws where it's allowed to issue some assets and participation of the society, and digital shares which are accepted at digital if they have legislation that covers it. They do not always have it from the moment that they are included in the government basis for financial assets. The digital financial assets can be divided into two classes from the point of view of digitalization. It's a requirement, financial requirement, as a debt that could be linked to the cost of actual assets like gold and oil, the papers, shares, with financial companies, which can bring profit from the investment. The Russian law covers that the court can block this type of assets and shares that belong to someone who is owing. In spite of the lack of this legislation on seizure and confiscation of property, it's applied general legislation in the civil law. Shares and financial, the confiscation of shares and financial resources is based on the description of the asset, explaining what's the meaning of which asset is. So after informing the people subject to the confiscation that it was ordered by the court, the person who is owing cannot access these resources anymore. So we have another steps that bring after it. We have to refer to especially to audit these resources, the digital resource. Then we give to a federal administration agents for seizure property. It's a federal agents that address this this type of property. It's a federal agent or a third party who makes the auction of this confiscated property. All these auctions are digital with authorized platforms. Another manners of digital rights are the utilitarian. We have the government has a list of rights, the right of transmission, and the right of transmission of exclusiveness of the of a property which is under the intellectual property law. They also serve for non-financial rights, organization of a work. They can appear in the level of a virtual environment. They cannot be required in case they have been registered, publicly registered. According to the Russia law, the digital the digital rights field, a property, a real estate that was registered by the federal government, it applies to financial assets. The only difference is that the purchase of a right, a digital right, has the right to the thing, and the right to requires the execution of a right or services. Now we are going to talk about coins, digital coins. I will not stop on the definition of these coins in the Russia legislation. They are not considered a coin in itself from the point of view of our law. Ruble, yuan, national currencies are not considered currently. We are taking care of tax collection, but the confiscation of digital coins is not provided by the law yet. It's difficult to detect the existence of crypto coins. This is made only in case of an individual investigation of for some crime that not related to financial, but that leads to financial law. We are creating a registration with the financial ministry in the coin. It exists. This registration exists since last year, and it will allows judges to find cryptocurrencies in possession of people that are being investigated. There is a it's something went wrong here. According to our opinion, it's one of the safest way to preserve the digital coin. To confiscate is to pass it to a wallet that owned by a competence. This wallet, the name is address identificator. The government determined that the ways to open these wallets by each agents, and now we are developing rules for the use of digital wallets by government agents and to regulate their uses. I believe that this measure will reduce the risk of use of these coins of these confiscated coins. It has not been regulated yet, the use of these coins. And the same for the financial assets. Uh, the Russia legislation can file collection cases against the debtors, the same way that we can work with the digital assets. The evaluation of these papers is made according to considering that cryptocurrency coins are always changed regarding the value. This approach is relevant. Um, I'd like to thank for the exchange of experience in the area of confiscation and determination of the existence of digital assets. Thank you very much for your attention. Thank you. Thank you. Now we are going to the second topic of our panel, that's the use of artificial intelligence in the lawsuits. I would like to invite to come here Invading Duck. Thank you. I would like to compliment all of you. I want to thank you for participating in this forum. We talk about the future that has already happened. Artificial intelligence is a tool, is a current tool, and it influences the law. Let's look back. The tax in the 20th century, this first automated systems were created, and they help to conduct some tasks. And every stage, the principle of law was the freedom for take decisions, the court taking decisions. I'd like to go to the next slide.
Про эру правосудия я уже рассказал, как это все развивалось. И
in this slide, you can see several rupture points in terms of these technological development in the legal sector. We had the scroll era, then we had books being printed, and then big data, and the start of the law is always the same. The principle is always the same. The independence in decision making. I believe we always have to continue the progress, but the principle has to remain unchanged. We can see a huge potential in digitization of the sort of process or lawsuit conduction, which reduces the workload on the courts with the use of AI. These are virtual assistants, transcription systems, hearings, virtual hearings, and the digitization of processes create transparent processes for all of the participants. We created a pilot project in that sense with AI that evaluates the received documents independently, which removes a huge workload from the administrative sector in the justice system. It also simplifies and speeds up the procedure among several instances. It's kind of hard today with this pointer. I'm trying to pass the slide, but it's not working.
Все разобрался. Спасибо. Да.
Now I think I understand. Okay, now I got it. We have 5 principles introducing intelligence, artificial intelligence. The human control first. This final decision always has to be made by a human. Transparency, quality and security, training, and the improved qualification or capacity building. Also, stage-based, step-by-step strategic integration. The BRICS countries are more than partners. It's a lab of the future. These are countries that have a huge technological potential where half of the planet population resides. So we believe it is really necessary to work on our cooperation, to exchange best practices in legal systems and in the justice systems. We keep up with the experiences of other countries. China demonstrates fantastic results using AI to check evidence, and India is the same. We have also used a lot to increase capacities, and Vladimir Putin has already said that the BRICS countries have a huge potential in this area. We're open for dialogue, and we know that there are a lot of perspectives to create unified standards in this area. We can exchange best practices, we can do pilot projects, seminars, webinars. And to finalize, I would like to highlight that we are at the eve of a new era where technologies will be sort of common, will be integrated into everything, but justice remains unaltered because no algorithm can provide justice. With technologies, we can defend the millennial principles of law. Thank you very much.
Da sequência.
Continuing now with our panel, let's invite the presidents of the Federal Chamber of Notaries in Russia, Dr. Konstantin Korvsky, to bring his remarks. My dear colleagues, in the name of the Notary Federation in Russia, I greet all of the participants of this event as well as the organizers. Thank you very much for the invitation, and I'm very happy to greet all of the participants. No question that the cooperation between the legal communities in the BRICS countries has a huge role to ensure stability as well as legal security with the growing socio-economic exchange as well as cultural exchange between our states. Obviously, the creation of a unified legal space that is reliable for the development of the socio-economical relationships between the BRICS country is impossible without the ensuring the rights and interests of the participants in social and civil society. In all Roman Germanic countries, where Russia and Brazil are included, as well as China, notaries have a huge role in the protection of the rights and legitimate interests of natural persons as well as legal persons. Acting in the name of the state, the notary ensures the legality of legal cases and is almost as a specialized witness, and it also removes some work burden from the legal system. We don't have any funding for notaries in Russia. All the 8,200 notaries in the country work based on self-financing. This is a solid system which ensures the stability of the civil transactions, protects the property rights, and prevents litigation, as well as fraud in the real estate sector, corporate sector, and financial sector, among others. With all of that, the modern notary in Russia follows the technological developments, developing digital tools that give speed, safety, and comfort with notary acts. In 2025, we have the electronic notary project having its anniversary with being implemented without any public funding. The release of the single information system for the notary in 2014, created by the National Notary Chamber, which contains all the notary actions done in the country, which is over 350 million registries. The notary is also an active participant in the electronic interaction system, which allows to do safe digital business in a single window format, with notaries being advanced posts for the registration institutions. The creation of legally valid documents in electronic format is a very important result of digitization. The Russian notary also has a central role in the development of the electronic traffic of legal documents. Today, citizens can sign digitally any documents or convert something into paper into a digital with full legal validity. 4 million people plus use this service per year, and since 2024, the Russian consulates abroad are also authorized to do these actions, allowing citizens to convert and send documents digitally even though they are outside the country. The public registries and online services from the notary become instruments of stability in civil relationships in Russia. Among the most used free services are the checks on any lawsuits with any real estate, the look for inheritance and search for inheritance cases, and they receive over 85 million consultations a year. Furthermore, citizens and companies can do several notary acts online, which includes the remote authentications with the simultaneous participation of 2 or more notaries. The search for these services grows consistently. In 2024, the number of long-distance transactions authenticated by notaries increased 1.7 times, and the demand has grown in a similar portion. This offers the companies and the state and everyone involved reliable instruments for safe legal relationships, increasing the speed and comfort of these procedures, as well as making legal qualified assistance more accessible. We also have an important amplification on the access to justice with the increase of legal costs in Russia in the last few years. The litigation has become extremely expensive for many citizens, especially vulnerable populations like people on retirement and people with disabilities. In this context, the notary has a preventive work trying to avoid litigation and protecting rights before the conflict even reaches the courts. The notary authentication grants the legal conformity of acts and prevents frauds and abuse, working as preventive justice instruments. The complete analysis done by the notary allows for the parts not to have to appeal to courts, avoiding significant expenses with legal costs and proceedings, especially attorney fees, among others.
защищать свои права в суде, нести.
Today, when you go to a notary to formalize a transaction, about 2 to 3 times cheaper than trying to file for a lawsuit and litigation.
Кроме того, в ряде случаев обращение.
In many cases, the notary offers an efficient and accessible alternative to litigation. Another example is an instrument of the notary executive deed, which allows to solve some failure to pay issues and delinquency without going to court. It can do to certify transactions or other agreements that involve the transfer of goods or amounts. Notary ensures the incontestability of the obligation, protects the rights of owers and creditors and debtors, and prevents money laundering and fraud. This procedure is frequently held in fully digital format without the need to be physically present at any location. In 2024, we had the creation of 1.3 million remote deeds, which is an increase of 53% in regards to last year. This is not just a quick and efficient solution, but also reduces the load on the legal system too. Just to repeat, it was over 1.3 million deeds that were created remotely, 56% with more than last year. Some notary acts, like some food agreements and mediation, also have executive power in case of non-compliance. The part that feels that they're being jeopardized can execute the agreement without any further need for further litigation. Another very demanded service is the notary authentication of evidence, not only in physical environments but also digital. The fact registered by the notary is automatically accepted by court as a valid evidence, including in ongoing lawsuits, including increasing the chances for people to defend their rights. The Russian notary has a strong social component. These notary consultations are always free, and there is exemptions and discounts for different categories of actions. The notary services are equipped with disabled people friendly tools that service very well the citizens with low mobility. The Russian notaries participate in social projects and also free legal advice campaigns, sorry. And alongside the Digital Development Ministry, we also created in our service website, in the public service support webpage, you can schedule an appointment. Then Russian notary is still the most accessible legal professional to the population with high technical knowledge, innovation, and public function. For the social policies in notary, the access to legal advice is simpler, quicker, and more inclusive. Thank you very much for your attention.
Following our panel, we are going to invite ex-co-member of the Bar Association of India, Ja Prakash. You can take your seat. Não, acho que não é. Oh, bem-vindos. Nosso advogado.
A member of Bar Association of Bharat, that is India. I am very much obliged here to come to our President, Sri Prashant Kumar Ji, who has brought me here on this auspicious occasion, a BRICS legal forum. And I'm also very much thankful to the organizer here who have given me this opportunity to speak something before you. Respected brothers and sisters of the legal profession under the BRIC plus countries, I am here in this panel which says is dedicated for inclusive governance, technology, and access to justice. In BRIC countries, we have talked a lot, the previous speakers since yesterday. They have enlightened us on different aspects of legal field and the role of jurists, including lawyers, judges, administrators. And we are here very much gained many things. Here I will say about the inclusive governance, technology, and access to justice in reference to those communities, those people about whom rarest of rare is spoken by anyone. In any forum, any gathering like this, and those are the indigenous people on whom I work. Since last 40 years, when first I visited USSR, the then USSR, I have traveled Moscow and nearby areas, Tashkent, Uzbekistan in 80s, late 80s. And there also I tried to study about the indigenous people of those territories, those geographical regions. Here, the inclusive governance is very much active in our country, Bharat, India. Since the time of the adoption of the Constitution of India, the authors, including Honorable Dr. Bhimrao Ambedkar, and the whole House of the Constituent Assembly in year 1948 and thereafter, had adopted this, explaining law in the Constitution for our country. The law giving so many notifications, what is a law? giving so many notification orders, act, rules, legislation. It is said, it is mandated that custom or usage having force of law is equal to law. And it worked. Inclusion of this in our constitution worked in inclusive governance, giving those people benefits, constitutional safeguards, who had no voice in the administration and in other fields, and who are the lowest, the categories of citizens who are not getting any benefits. They have got benefits. They have been benefited. And in India, there are more than 750 scheduled tribes living in different geographical regions of the nation. And they are getting their share in not only in inclusive justice, but their access to justice. And that is why, to solve their problems, judicial litigation and the disputes in our country, in the year 1987, Justice Bhagwati has taken a march on this, lighted a light in the form of Public Court, Lok Adalat Act. And by that, the judiciary, the executives went to the people in their villages, in the remote forest areas, and camped there in the form of the Lok Adalat, and solved their problem. After this corona, our Supreme Court, the Chief Justice of India, now retired, Justice Chandrachud, has very much started very forcefully a court for all, and it is working just for accessible justice to those people. Similarly, because I'm at present here in Brazil, I have studied about Brazil also. In Brazil, there are about 305 tribes, and their population is, as it is given, more than 8% of the total population. And they speak more than 200 dialects, are spread in the different geographical regions of this country. They are fighting, all the indigenous people of the world are fighting for keeping their identity intact. And that is why they have been survived thousands and thousands years, their communities still alive. And wherever they are happy with this situation. But when anyone encroaches them, disturb their situation, their position, they became very much furious. They don't tolerate it. I have given so many instances of this. I will not go in that because paucity of time, but I will write it. Actually, I am writing on this. Their customary laws, customary uses, having force of law of the Indian tribes in 17 volumes. And wherever I have gone, I have seen it. And I will just here urge one thing. This forum should take care of them. They need your support in keeping their identity intact. They will survive. Only need your concerns to take care of them. To take cognizance of their problems. They need your concerns. So in BRICS level, this legal forum for humanity, because one thing you will find in this BRICS Plus, the participating countries are having more indigenous. They have indigenous people. They are indigenous people. Maybe they have lost their tribal character, but they are indigenous. Because tribes and indigenous city is some difference. Tribes, when there are some criteria, ingredients for to be a tribe, to remain a tribe, and when this ingredients goes away, people come out from that, though they are indigenous. So these are the indigenous countries. People not have come here from very far, who have come here, mixed here with the population, and safeguarded them, safeguarded their culture and customs here. One incident in Brazil, I will explain before you about the Sandido Rondon in Brazil, who has first in year 1910 helped establish the Servicio de Proteção nos Indios, SPI, now known as FUNAI, Fundo do National do Indio. So there are the people under whom the fire is burning. Who are there, like our Mahatma Gandhi in India? Oh, here also peoples are there who are compelled to help them. And that is why I urge this auspicious gathering. They eliminated people, the lawyers, the judicial persons, jurists, to help them in keeping their identity intact. That much we can do. And that is all. Thank you very much.
Now, we are calling the Associate Professor of International Law of the Utah University's Political Science and Law, Fei Xuan, to bring the approach on the governance of artificial intelligence in China, incrementalism and multilateralism. Eu vou falar
China's AI approach to regulation. And in fact, from the topic, you can see incrementalism and multilateralism. That are the two objectives that China is pursuing in AI governance. And here, incrementalism, I mean that China, in fact, is trying to learning how to regulate AI, because AI is an emerging industry, and a lot of countries, they don't have experience in regulating it. And multilateralism, I think, is very familiar to all of you. So I will go to the next page. It does not work. Next page. Does it work? Next page. Okay. Okay, no problem. Yeah, it works, but okay. So this slide shows it's not a law in China. It is a soft law development plan. It was issued in 2017, but in fact, it is the guiding principle for China's regulation on AI. And yeah, there are several objectives that you can see. And from this development plan, you can see that there are 4 basic principles that China focuses on: technology-led and systems layout, market dominant, open source, and open. From those 4 principles, we can see that, in fact, China is trying to respect the market development, not about the political dominance regulation on AI. No, not in that way. China is respecting the natural principle of the technology development and try to let the market to promote the AI. That is the most important idea. And meanwhile, China also promotes open source. So open source, I think, benefits all the human beings. And we know that, in fact, a lot of Western countries, they are very advanced in closed-sourced AI. But China is trying to do the open source. And China is also trying to cooperate with other countries in AI development. And about the value alignment, so AI, there is the value embedded in the AI models, our AI systems. And of course, in China, the AI models or systems should be aligned with China's core socialist values. But you can see the words highlighted in yellow color. So there are 12 words about the core socialist values. I'm not sure whether you are familiar with China's core socialist values. In fact, most of you can understand those values. They are not particular or bizarre, I think. In fact, those core socialist values are in line with, I think, the values written in the Human Rights Convention by the UN. And the next part, I will talk about the AI-related legislation in China. Just as I mentioned, in fact, China is very careful, not that, for example, we know that in the EU issued EU AI Act. That is the comprehensive AI regulation. But in China, we do not have AI comprehensive regulation. We have the sector-based regulation on AI because we are trying to accumulating the experience from the practice, from the deployment of AI. And then when we have enough experience, we will try to make relevant regulation. And we can have a look about the legal documents issued by Chinese governments, our legislators. There are around eight legal documents issued in 2025. So those documents are all soft law. There is no hard law. Soft law means they are very flexible and adaptive. And China is also paying a lot of attention to AI deployment. So in every sector, for example, pharmaceutical or healthcare, our banking, our judicial area, in fact, China is encouraging all the sectors to use AI. Only if there is enough use of the AI that the regulators can get the experience, can see where are the problems and how to regulate it. And those are the legal documents issued in 2024. So just to give you a general picture about the regulation in relation to AI in China. And the two documents highlighted in red letters, they are hard law. But we can see the first hard law is about the personal information protection law of the PRC and data security law. So on one hand, China is trying to emphasize the protection of private privacy, our natural person's privacy when people are using AI. And on the other hand, in fact, China is also paying a lot of attention to data security. So China is trying to balance how to respect people's rights and as well as to make sure national security is safeguarded. So now I will talk about the data regulation in China. That is the part I think maybe some of you may be interested in. For example, about the personal information protection law, because some foreigners several years ago may criticize China that, for example, during the COVID-19, about the facial recognition by the AI technology was deployed in China, especially during the COVID-19. And a lot of people criticize that may violate people's privacy. Therefore, China responded by issuing the law to protect people's personal information. And of course, if there is the situation about the data transfer across different borders, so there is different thresholds that will be applied to the data security review system. And this part about the promotion of data sharing among the governments is the new initiative promoted by Chinese government. Because we know that data is very important for the AI development. So China is trying to encourage governments, you should share public data between among your government officials, our government different sectors, so that they will have a very good databases to train AI model. And of course, about the data sharing, the EU has also been done a lot of work in that area. And I think China has learned from the EU in this respect. And the fourth part is about the AI-related patent protection. So I think in most countries, we know that only natural persons can be authors. And a lot of governments are very hesitant in how to regulate AI-related patent protection or AI-related copyright protection. And of course, in China, we require that if your invention or your work can be qualified as the IP right in Chinese IP law, the work your invention should be very creative and make contribution to the science or to other aspects. And inventiveness, of course, is required. And this is a real case about the copyright protection in China. And we can see the plaintiff and the respondent. Plaintiff is Li, and respondent is Liu. And the four pictures, beautiful ladies, they were generated by AI models, by the plaintiff. So plaintiff, we can see this AI model. The plaintiff used this AI model to generate the four pictures. And the plaintiff needed to put in the words such as he wanted to generate a very beautiful lady, for example, our Asian look, our big eyes, the skin is white. Those prompts words to generate the pictures. And meanwhile, the plaintiff also need to put in the negative words. For example, the lady should not be fat or should not be not good looking, or those negative words were also given to the AI model. And the plaintiff also adjusted several parameters, including the length or the width of the picture, and to generate the four ladies. So the dispute is that whether those four pictures can be protected by IP law in China, because a lot of countries, they may consider your pictures or your works are created or generated by AI. In fact, there is no innovation, but China considers the plaintiff's selection of the parameters and put in the prompts. Those efforts made by the plaintiff can be qualified as innovative. So in this case, in fact, the Chinese court recognized the IP right of those four pictures. And that instance, in fact, is different from the US or the EU's instance. So in other countries, the pictures generated by AI models in most countries, cannot be protected by IP law. But China wants to encourage people to use AI. And so that is the reason why the Chinese court granted the copyright to those four generated pictures. So if a country wants to promote the development of AI, they must provide the protection. Although that may be not so in line with the traditional IP protection conceptions. So I will skip those parts in case that you feel very worried. And about the AI employment or application in China's judiciary. So in China, we have the 3 internet courts. So AI is well used in those 3 internet courts. And meanwhile, a lot of Chinese courts, they use their own judgments, data, to train the AI model. And those AI models, of course, are not open source, or the AI models can only be used by the courts in order to protect the security or the rights of the relevant parties. So, but a lot of courts, they do not openly state that they are using AI models to deliver the judgments. But they are trying to train the AI models, and in some cases they may use, but not that instance. So they consider the situation is not mature. So in judicial area, China does not issue very strong law in regulating how to use AI, like how the judges or lawyers should AI. In fact, China is trying to accumulating the experience. So, okay, I will skip this part. And about the, so that is about the part of the China's approach in incrementalism. And now about the multilateralism, in fact, China endorsed the UN to be the main body in global AI governance. And meanwhile, of course, China has, I think, tried very hard to push forward the AI governance cooperation among the BRICS countries, as well as in other regional arrangements. So those are several concepts that China is trying to endorse. And of course, in the current situation, we know that the US and China, we are in the high-tech competition. So China is trying to be open and multilateral to cooperate with other countries. And of course, that will benefit China as well as other global south. Okay, thank you very much.
Agora a gente vai passar para o tema.
Now we're going to go to the topic, the risks of AI in the access to justice and the protection of the citizens' rights. Now I'd like to invite Syed Mohammed Mahaji Gamami, Deputy Professor of Public Law at ISO University, Tehran.
Bismillah ar-Rahman ar-Rahim. Ladies and gentlemen, good morning. I will be talking about the risk of AI in access to justice and the protection of citizen and human rights. Artificial intelligence is a growing technology that will not only influence but increasingly transform and sometimes completely take over various areas of human life. Many vital social, economic, legal, public, and judicial services for all citizens and residents of most countries are provided by AI. Although the initial step in the development of AI have claimed to increase welfare and development, but it has unpredictable and dangerous effect and impact on social, ethical, and cultural life, such as security and safety human life, such as security and safety of human life, the flow of justice, fair distribution, wealth, and power, the fight against crime and corruption, job stability and employment, protection of privacy and personal data, compliance with competition rule in trade and business, psychological security of society, etc. How can AI technology be managed in legal terms to secure and guarantee access to justice and also citizen and human rights? The Framework Convention on AI and Human Life, Democracy, and the Rule of Law was signed on 5 September 2024. This convention, in 8 chapters and 26 articles, established fundamental principles for AI governance, including transparency, accountability, no discrimination, and human rights. But are these goals respected and implemented by its high contracting member state? Not at all. There should be general obligation for a state to implement and secure access to justice and human rights for people from all around the world without discrimination and dangerous algorithms. This obligation must be initiated by countries that have not used the technology against humanity through an international convention. The Israel is a party of the Framework Convention on AI and Human Rights, but he misused the AI technology for extrajudicial killing and the war crime and genocide. This is the case of Stapel. The Israel publication reported that this method, an AI system dubbed Harbosa, led to many of the thousands of civilian deaths in Gaza. More than 68,000 Palestinians have been killed in Gaza since 7 October. Nearly 60% of them were children and women. Let's be clear. This is an AI-assisted genocide, and going forward, this needs to be called for a moratorium on this use of AI in the war and violation and genocide. BRICS legal authority and institution and their lawyer should draft and ratify an international convention to prevent the misuse of artificial intelligence to violate human rights and the rule of law and the secure global trade by terrorism and the criminal government. The lawyer can draft the initial text of this convention. We definitely can. Thank you for attention.
Eu gostaria de agradecer a todos.
I would like to thank all the speakers for this brilliant panel that we close now. Now I'd like to ask
Please, your name.
Сейчас я...
Eu sou Vladimir Lapatin. Now I'm going to ask a question as Vice Director of the Institute of Copyright and also as an expert of the UN. In all of these sessions, we had the mention of copyrights, right? In Russia, there are several discussions being held about AI, and also, like our colleague in China mentioned, I have a question now. AI is an information system which contains technology, information, and some algorithms, some technological means. So it doesn't matter how we call it. AI is an information system. In the UN, we had a discussion over several years. Is this an object or a subject of law? And a copyright. For example, we heard a position that for the development of the AI, recognizing something that was created by a AI network should become the object of copyright. But because of the UN agreement, which is recognized by the BRICS countries, each work of art needs to have a natural person as an author. Before we could have legal persons, but nowadays it's only natural persons. There's no other possibility, no other way of interpreting this law. If we consider works of art generated by AI as authors, then who would be the author, right? So we shouldn't do that. We shouldn't think that the programmer should be the author of the work of art. But now we're talking about developing standards for AI and intellectual property. Considering that there is a product which was created by an author, there is a database that was loaded into this software who was also created by someone and is owned by someone. And there are technologies that enable or promote machine learning, and these softwares also have owners. And there are technologies that enable to set the information, to host the information in cloud, and a series of data processing centers. So this will increase the competition. They will multiply in several levels and several fields, defending the interests of several countries and organizations. All of that will be connected to copyrights, but the subject with regards to something produced by software, database, so on and so forth, that are used by these softwares, regardless of where they are located, the owner should always be an author, a natural person. So I wanted to specify that we respect the Chinese practice and experience. And once again, I wanted to ask if I understood correctly that in the case of recognizing photographs as a member of copyright, who is the author? Is it the person that created the program and not the person who uses the technology, the person that sort of created the AI? This is a very important question that should be answered, because this is a problem we're gonna face in all the BRICS countries, and the humanity as a whole will have to debate this, because this will determine the future. I also like to highlight this and also invite everyone for this 6th panel, which will take place after lunch in this room about this topic. Thank you very much.
I think that it would be interesting for this question. I would like to invite Professor Fichuan to bring some comments. I don't know if she's attentive to. Thank you. Claro, sobre o autor, os inventores, na maioria dos países, somente seres humanos podem ser os inventores.
Law is aimed to encourage humans' innovation rather to encourage AI's innovation. So in most countries, only natural persons can get the authorship, the inventors, that identity. But there is an exception. In South Africa, only one case, South Africa gave the IP protection to an AI model. So that is an exception. And about China, I want to talk about China, of course, about the case that I talked about, the 4 pictures, that case. In AI, there are different people may be involved. For example, maybe the designer of the AI model, that is one person, designer. And of course, there is the deployer of the AI model. And for example, we may use app, and some company may deploy those apps on internet, and we may use them. So there are deployers. And of course, deployers are deployers. There may be, before deployment, there are the designers, or the designers of the AI model. And of course, there are also the users of the AI model. So at least there are 3 categories of people are involved in AI, our generation. So who can get the authorship are the protection under the IP law. In most countries' law, those three categories of persons who are making the most significant contribution to the generation will be protected by the IP law. For example, in that case, about the four pictures case, in fact, that person, the plaintiff, is the user of the AI model. And the court, Chinese court, considers that user, in fact, he has tried many times to generate the pictures that he preferred. And the court considered that those pictures are very personal, innovative, reflecting that person's, that user's preference. So of course, Chinese courts want to promote people to use AI. So the court gave the authorship, protected the pictures under the Chinese IP law. But we should pay attention in that case, it is not the AI model who has been granted the IP right. It is the user who has got the IP right. And I think it depends on different countries' positions, what you want to achieve. So, of course, if you want to promote the AI usage, the AI innovation, I think different people's involvement in AI model, including the designers, the scientists, the computer scientists, and also the deployers, engineers, or maybe the users, all the people's interests should be taken into account. And there are the differences between the extent of efforts. For example, maybe the designer does not care about the authorship or the inventor's identity. Because in that case, about the four pictures, the designers and the deployers, they clearly stated that they didn't want to have any IP protection to the pictures generated by that AI model. They gave up that right. So the users, if they could do something special, they can get the protection. So it depends on what your countries want to achieve. And I think that is very important for your country's AI development. Okay, thank you very much. Thank you very much.
Eu gostaria de convidar todos
Invite you all to take the certificate and take a picture here for the record. And I would like to thank the participation of all of you. It was a brilliant panel. Thank you very much.
Informamos a todos que haverá uma pausa.
We have a break for the lunch. Everyone is invited. It will be served on the 5th floor. The forum will continue at 2 with the panel number 5, Education and Legal Teaching.
Senhoras e senhores, boa tarde.
Ladies and gentlemen, good afternoon. Continuing the works, we will go now to the panel number 5 with the topic Education and Legal Training, with the moderator being the decane in the International Law School for the International Relations State Institute in Moscow, Dr. Nikita Monchakov. As speakers, we have the Secretary, the Executive Special Commission of the Legal BRICS Forum from the OAB, Dr. Bruno Barata. The Vice President in the OAB Minas Gerais office, Dr. Nubia, with the President of the Academic Commission of the Rights of Law and Associate Professor in the Commercial Law School in the State St. Petersburg University with a PhD in law, Dr. Alexander Alexenko. The Professor of the Private Law Department in the Legal Support to the External Economic Activity with the Substitution of Imports and Industrial Development from the University of Moscow State Law, Dr. Benjamin Sarnazarov. The judge in the Community of Independent States Court, decane at the Superior School of Legal Studies, and the Civil Service of the President's Academia for the Russian Federation for Public Administration and National Economy, and member of the Council of the Russian Bar Association, we have Dr. Oleg Zaitsev. He's the General Secretary for the National Bar Association for the South African Bar, Dr. Sinsedili Chicha. Now, to conduct this panel, we give the floor to Dr. Nikita Molchakov.
Of this panel discussion, and в прошлом году
last year, the 9th forum took place in the city where I am decane, and one of the most important discussions in the forum discussed the legal education, and many of the people who are here with me today participated in that session. Many programs and problems that we discussed last night, yesterday, and today in the morning require high level preparation from jurists, and that is why legal education is one of the most important topics for all the legal communities in the BRICS countries. We should prepare a text with experts which will work considering the changes that are going on in the world right now. And the world is under the influence of a series of factors, like, for example, digitization, the adoption of unilateral sanctions. I can also name the international law revision and the comeuppance of a new ways to cooperate between states and professionals, in our case, for example, jurists. And one of such ways is also BRICS. BRICS actually is its best characteristics is the fluid way that it enables for the cooperation to exist among our countries and our legal communities. And we should have a unified vision for this legal education, regardless of the country of origin. The problems are similar. If you'd allow me, I'm going to mention a few words about the format of the presentations. 10 minutes each, and let us try to hold ourselves accountable for this time limit, and perhaps at the end of the session we can have some time to discuss with the public. E com isso, eu passo a palavra. With this, I give the floor to the first speaker. This is not everybody knows it's a person that somebody knows very well, Professor Bruno Barata. He's an attorney who worked very, very hard for the ideas that are being discussed in the legal fora come true in life, including legal education. Professor Bruno Barata, could you please tell us about the summer schools organized for the BRICS countries' representatives in Dubai and Lausanne and other cities? I think it would be an interesting experience to share, and we can perhaps discuss our conversation around it.
Let's see that we can bring all data from the memory. We control the time, not be tired. Good afternoon, everyone. Nikita, thank you very much for your words, for the introduction. It's a joy to see you again. We've been together in the BRICS Forum in Moscow last year. It was held in Nagimo University. He's the dean of the law school, a very good space in Moscow. It's a great opportunity. We could have a very intense activity as this BRICS activity. Our talk this afternoon is about the law teaching and education. I would like to talk about a little bit about the Bar Association in Brazil has been done in the sections in the entire legal market in Brazil, the continued education, the legal continued education, that's very important for all of us. We know that the graduation can't bring all the things that the lawyer needs to learn to be a good lawyer. There is some lacks of disciplines from the basic ones. I'm talking the Brazilian context. How to negotiate the attorney's fees, how to behave in a trial before a judge or a justice, the oral argument, things that are very simple that makes a difference in our daily lives, but we don't reflect of how important there is to qualify us better as lawyers. You know, it's a very interesting profession. It's a very hard profession. There is a competition. It's a health competition, but we fight for the customers. We have to qualify for this. Teaching is very important as the defense of the advocacy prerogatives. Things that the Bar Association perform very well. And internationally, the Bar Association has the position of aggregating not only BRICS countries, but also in the G20 that we had last years. We have the participation of some countries of BRICS. We always have this educational bias. Besides a lawyer, we have two parts in the education. One, I coordinate two institutions, one in Brazil, in Switzerland. We always have this practical tendency. I have this point that I'd like to bring you, some reflections. At your disposal for a longer conversation as the adult has to learn. It's a very important point. Sometimes we talk about pedagogy, but pedos means child. We are talking about kids, but we forget that how kids learn is different from how we adults learn. It's a very big difference. We change our capacity of absorbing information. It changes a lot. We have the concept of andragogy. It's the teaching of adults. Today we have the cell phone. We receive a lot of information through the cell phone, and we can pay attention for long. Some concepts it involves neuroscience. Our capacity of absorbing information of an adult is about 20 minutes. More than this, we have problems to comprehend information. What we try to do in these courses and events is try to pass information in a way that the adult can understand it better. It makes a difference in education. Sometimes I'm invited to give a lecture. I was invited to impart a class. It will last 3 hours. I can't. I don't take to teach for 3 hours. It's a lot. Everybody will get tired at the end of the class. Also, the professor won't be able to talk for 3 hours continuously, and students won't learn everything. The way we teach, the way how we teach is very important. Is the conception of how teaching is done and the execution. So the Bar Association has a very good tendency in the teaching. We have the part of Bar Association education. We offer a lot of different courses for all the lawyers in Brazil. We are the country of the numbers. I mentioned it yesterday. We have more than 1 million and we have almost 1,400,000 lawyers. It's the biggest number in the world. We have the biggest number of cases is in Brazil. We have a lot of cases pending in the court. As we have a very big number of lawyers, it's also important to train them. We have to qualify them. We are very worried about exercising the law and the trials, the deadlines, and we forget about the education. The Bar Association has this important role of promoting education for these lawyers to qualify them, for them to learn new topics, and promote the development of the law in practice. Recently, the Bar Association got an approval with the Ministry of Education for the College of the Bar Association. Soon will be a law school, and we'll provide the course for future lawyers. Post-graduation that we already have in partnership with other education institutions, but now the Bar Association will be an educational institute, which is very interesting. So we will have this better service for the lawyers. We are very worried about it. I would like to talk about the experience that we have had inside the Bar Association. There is a term in English, lifelong learner. We have to be learners for our whole life. We received the degree, and then some people stop it, but we have the master degree, and sometimes people think that it's over and now I don't need to learn more. But we learn every day. We don't stop learning. We don't need a course for this. We just have to be just have to understand that we are always learning. We negotiate every day. We leader every day. These notions of soft skills is very important for the lawyers to learn how to negotiate it. To lead a team of 500 people. And if you have 2-3 people, you are exercising the leadership. We have to learn it every day. Not only the bar association have to offer these opportunities, or the schools, the law schools. Um, we have to, as professionals, we have to be open to receive this information, and to learn all the time. If you think that we learn it and don't need to do anything else, people who think the different will replace you. When we talk that the lawyers will be replaced by robot lawyers, I don't think it's going to happen. But lawyers that are not prepared to use the artificial intelligence in practice, they will be replaced. Will be replaced for those who are learning to use artificial intelligence. More important than the bar association, the lawyers, and the law schools is our mindset that has to change. We have to be open to for the continuous learning, so we can evolve in our profession. I'm at your disposal for any question that you may have. This this presentation approaches some address very important topics. I will call your attention for a very special one. Is in the education for adults. First, we associate education for the adults as in the increasing of qualification for those who are already has a education. In Russia, not always we give attention, we pay attention to this, but it has been changing lately. Another important moment, I represent a university which pays a lot of attention to the study of international law and foreign law, the law of other countries. It's very important in the context of the BRICS countries, because we should know each other better. I can present you some statistics. There is no expert in the Russia Federation, expert in Brazilian law, and I think that in Brazil there are few experts that study the law of Russia Federation or South Africa. It's a very important area. I think that all the universities and law schools should work on this area. We should learn each other better, because it's the main topic of BRICS is the unity in multiplicity. I would like to give the floor to my friend. Ah, no. I'll give the floor to my friend who represents one of the oldest law school in Russia, the St. Petersburg University in the state of St. Petersburg. Alexander Petrovich is going to tell us a little bit about the traditions of the University of St. Petersburg. Queridos amigos,
I would like to deliver a short speech about comparative legal analysis and researches which we provide in our university, in St. Petersburg State University. Our university have a long history, more than 300 years, and we have prominent students and prominent graduates. For example, two Russian presidents, they graduated our university, our exactly law school. Also, the leader of Soviet Russia, Vladimir Lenin, graduated from our university. Here you can see some brief statistics. concerning cooperation with BRICS states within our university. These agreements, they are including different spheres. And here you see 50 more agreements with Chinese universities, 42 with Indian universities, so on and so forth. But if we will open these agreements and trying to find something about cooperation in legal sphere, these 50 more agreements, they will be 20 more agreements, and 40 more agreements will be 10 more agreements, and exactly one agreement with university from United Arab Emirates. It is not about cooperation in the legal studies. Here we can see really big problem. We know nothing about each other. We know nothing about our legal systems, or know very little information. Here you can see some information about our law faculty. Actually, it is not concerning my speech about comparative legal studies. By the way, here you can see two our academic journals. And now we are trying to attract authors from different states, including BRICS states, from China. We have authors from Brazil, India, and South Africa. So, dear friends, if you have any academic ideas you are going to share with us, we welcome you in our journals. Why I'm talking about our journals? Because in our university we have a specific center for comparative legal studies, and the main aim of this center is to provide information for Russian lawyers, Russian students, Russian public bodies about legal systems of BRICS states. As Professor Molchakov said, today, unfortunately, we have no specialists who know something about Brazilian law, the same situation with South Africa. And now we are trying to change this situation, but we need study, mutual study, legal systems of the area of every BRICS state in order to strengthen our cooperation. Without understanding principles of the legal systems, without understanding legal traditions and legal cultures, I guess there will be really not good results in economic cooperation, so on and so forth, because growing economy, it needs understanding how to protect rights of investors, merchants, so on and so forth. Now, fortunately, we have a program aimed to teach Russian students, exactly Russian bachelor students, Chinese law. Here you can see some information about our program. This program next year will have 10 years anniversary. I am not only Vice Dean of the faculty, I am also academic director of this program. And we are trying to teach our students not only Chinese language, but also Chinese culture, Chinese legal culture, and also Chinese law. And the first of all, commercial law, arbitration, and civil law, because knowledge in this field, they give best opportunities for our students in future when we will cooperate with partners from China. And also, we now preparing our teachers, because in order to teach students, you shall have teachers who know something about the subject. And our teachers, exactly me, for example, we participate in different academic research programs connecting with Chinese universities. And we now have 2 academic projects concerning Chinese law. And also we have PhD students, Russian PhD students, who are interested in Chinese law. And I guess this is a really good example of studying and teaching the law of the BRICS. In Russia, we was the first university who launched this program. Now this direction becoming more popular. In other universities, they also started this something like these programs. And what the main idea of my speech, it is that in order to provide cooperation, we shall first of all study about law of each member of the BRICS. And you can see that there are a lot of differences within BRICS states, and different legal principles, and different legal systems, and different legal culture. And how you will cooperate without knowledge about all these differences. So, dear friends, I would like to stress on one more your attention, that in order to build future, we must start from not today, from yesterday, to create a basis for mutual cooperation in the sphere of legal teaching and legal studying of the BRICS states' legal systems. And in that case, our lawyers, our students, our graduates, they will be acquainted with specialities of every state, and it will be a really good chance to build together in the future one common maybe fruitful and maybe also with good results, some commonwealths. So, dear colleagues, if you have any questions or ideas concerning BRICS legal systems and analysis, I am open for cooperation. Here you can see my contacts. Let's build the future of the legal teaching together. Thank you for your attention.
Спасибо, Валерий. Thank you very much. Но как раз форум.
This is a platform where you can actually establish these kinds of contacts and get to know each other. Now I'd like to give the floor to the next speaker, Lumbia de Paula, Vice President of the Institute of Minas Gerais, named by Mr. Bruno. And I'd like to say that we have a very warm relationship with the state of Minas Gerais, because this summer many Russian universities participated in a summer camp for BRICS at UFMG. Please, the floor is yours. Hello, I'd like to greet all of the people here present with a lot of pride, pleasure, and joy that I am here representing the sectional office of OAB in Minas Gerais. I'd like to thank Bruno Barata, our ever professor, for all the activity that he works on the national office, and the president, Beto Simonetti. These are two men who always open the space for cultural connection and exchange. Dr. Bruno does it and will always do it brilliantly. Thank you, Professor, for the space. Now, I'm going to talk about a very dear topic to me, which is the decolonization of legal education. And when I talk about decolonization, what do I mean? Just so that we can think about it. When I talk about legal education, the main question that we need to answer is, whose law do we teach? What world does the code that we open come from? What voices, what bodies do they represent? These are things that are not rhetorical questions. These will reformulate the ways that we need to restructure legal education in the globe. This legal education that had a very strong heritage from the European 19th century system. We do not deny this heritage, but it is a legal education system which brings Latin American countries and Brazil as subjects of law and not objects. As objects of law and not subjects. Sorry, I apologize. And we need to change that. Something else that brings me to this reflection is the Eurocentric model. And the problem for this model is that has two biases. First is epistemologies. There is a gigantic epistemology to nullify the knowledge that is different from European, and the epistemic sort of selection, which is to take ownership over cultures that don't belong to you. In this epistemic colonization, think that, for example, me, as over 20 years of experience in law school, as a teacher, as a professor, we have a curriculum that was shaped in things that don't represent our reality. Our students here in Brazil, and I've always made this criticism, they a lot of the times learn the Roman law, Latin law, European law, but they don't know the Amazon reality, the favelas, the quilombos, the original people's realities. What law is this that doesn't represent the population that is represented in that country? This legal education doesn't have to look outward. It has to look inward to where we are located. I need to change places in order to change. I need to change the local to change the global. And this requires for us to acknowledge what is close to us. And this is the problem with the Eurocentric model, is the hierarchy of knowledge. Since when has this existed? Since when is certain knowledge superior to others? Since when a European culture is better than the knowledge of a quilombola peoples who do something completely different? And it is in this reflection that we have to ask ourselves, what does it mean to decolonize legal education? And once again, I'm not denying or refuting the contribution of European culture to our system. I'm not saying that we need to trash the whole contribution of the European system. No, I'm not. What I'm saying is that we need to consider other civilizatory frameworks to construct this legal education. And that's what I advocate for. When I say that Europe needs to stop being at the center and their legal knowledge needs to have no longer have the hierarchy over other knowledges. Our knowledge in the global south, BRICS countries, and Latin American countries, especially Brazil in this case, these are sources for education and culture. But there is a huge European imaginarium that Brazil is only a student and not a source for legal teachings and education. And that is the major mistake with this model. We're students, but we're also producers in this culture. So, to decolonize legal education means to say we also know. Decolonizing legal education is sort of denying the neutrality of it, because no legal teaching is. Each discipline, each matrix tells a story or hides it. And that's what we need to reflect about. Decolonizing legal education is to say that there is no hierarchy of knowledge. We need to stop the epistemic pillaging and epistemic neutralization. I refuse to acknowledge this as a European origin, things that Europeans just took to themselves and they say it belongs to them, but it's not. They took it with no permission and they took ownership of it. And taking ownership of something that is not yours is not legitimate. Denying the existence of these marginalized peoples, of the feminist struggles, of the black peoples, of the LGBTQ AIPM plus that also produces knowledge is also not worthy, because these are knowledges that change lives. So it means that we need to have some sources of inspiration. Here I would like to name 4 of them. First, Boaventura de Souza Santos, which I know you all know. He is an inspiration for the decolonization because he says there is an ecology of knowledge. Your knowledge is as important as mine. And if there is an ecology of knowledge, and if there isn't an overlap of such knowledge, then let us live in harmony with these knowledges, contributing with each other. And I have a passage, an extract that he says, there is no ignorance in the self. There is only delegitimized knowledge. And that's what we seek when we try to talk about decolonization of legal education. Why have they been delegitimized? Because they are worth less? Who said so?
To who it values less. If a people is made of minorities or minorized, why the rights of these people do not need to be in our curriculum of the law school? We are training lawyers, graduating lawyers and judges to have the truth, or to have what we want them to see, for them to see what we want them to see. Another inspiration is Catherine Walsh. She talks about the critical interculturality. She will talk about it. There is no hierarchy in the legal teaching. There is no hierarchy in the knowledge. She says that the critical interculturality is a process of transformation. If I deny it, I recognize that it's a horizontal talk between these knowledges. The same as Aníbal Quijano, he'll talk about the colonization of the power. It's not possible without the coloniality. Hierarchy, no respect to that they have been subjected to that knowledge. And I should mention Sueli Carneiro, that when she says that the absence of black people and peripheral people in the epistemology is also a form of symbolic violence. I know that black people try to hide in our culture for a long time, but then we said it's enough. Our culture is also important, it's also knowledge. What's the role of the legal institutions? Change dialogues. To be open to the difference. If we have been equal until now, we are not equal anymore. Do you know why? Because we can, Turban cannot make a lawyer to be impeded from entering the court. The global south is not a place of absence, it's a place of potency, power, and we have to know how to claim this right. And what's the path for the decolonization? What we are doing here? Dialogues, hearing and respect, and mainly wanting to change. And back to the initial question, to whom belongs the law that we teach? It's mine, it's yours, it's your. It's a lot of voices and a lot of histories. Thank you, everyone. Thank you very much. Professor Paula, I'm going to say something that is basic, but I think it's necessary. Let's love our national law and not talk about what the one law is better than the other or a law is worse than the other. And let's uh, begin from the point that we should uh, differ our laws with better international practice, but not replace our legal system with ideology. Um, as the example that Professor De Paula gave us with the Brazilian law. I'd like to call your attention to the fact that let's learn the language of the BRICS countries. We are used to the English, German, French. Today, in our cooperation, you should learn Hindi, Chinese, Arabian, Portuguese. I I'm saying this because I represent our universities that in the Guinness Book of Language offer, but we offer all the languages of the BRICS countries in our university. And learning our languages will make us understand better the legal systems of these countries. It was not There is not much material translated into English of the practice of the BRICS countries translated into English. I would like to give the floor to the dean of the very known university in Russia, the Presidential Academy. He's going to share his experience at the university about the education. Dear colleagues, good afternoon. I'll speak in Russian today, and I know why. I invite you to learn Russian. We have a very rich culture, and this presentation it's in the report of yesterday. We have a very rich culture. In this forum, we had some cultural events at the University of Rio de Janeiro, UFRJ. There was an exhibition of one of our presenters. I would like to talk a little bit about the development, about education in the BRICS context. It's important to talk about some concrete examples that we can prepare for tomorrow. Literally for tomorrow, because BRICS has existed for some time. And the discussion that we have about education, it's been existing for a long time. It reunites a great number of jurists. I'd like to call your attention to the fact that it seems that legal education, it can seem that this topic is not very important for the jurists, but because we have already passed this stage and we want to practice how to make the arbitration awards, which institutions work, how they work, how to celebrate weddings, how to enter into agreements. But the legal education is the basis of our education. Without a legal basis, we can't be here. We couldn't be here discussing the problems that we have discussed all these days, and we are going to discuss still. It's a very important topic. also here in the BRICS. I'd like to propose to create a group of education to be mandatory in the next forums. We should discuss about it, thinking about the future. And when we talk about the studies of legal systems of BRICS countries, I would like to highlight and propose to the university colleagues, the acting jurists, it would be good that each of us create a course about our legal system and include it in a platform. If we find a correct methodology in the creation of this course, each of our universities could use these courses in their curriculum for the students. It's very important. Uh, no university can grab that they have an expert in each legal systems of each BRIC country. They can say that we are creating, we are educating. We should educate these experts. We have a platform, a very good platform, in the legal platform of BRICS. New colleagues join us, and then we bring others. Bigger number of people, and we should introduce these people to each other, unite them, and from this point of view, let's mention the summer school that happened in Minas Gerais in August at the Federal University. And what I noticed is that the students heard the conference, they were interested, but the most important thing was the human communication. As the students were talking to each other after the conference. And I'm sure that these people kept in contact. And maybe it's more important than the studies of the legal systems of a country of the BRICS. We could imagine a centralized system of courses, and I would like to make another thing less centralized. We could have only one summer school, for example, in India. Our universities of each country could autonomously create this school for our students to meet each other. I have another proposal. Maybe it's a proposal for us, professional jurists. When we talk about the necessity of studying and applying the legal systems of BRICS countries in the international agreements that are enter between our customers, we should use in this case the legal systems of the contract parties, and not saying that the international rules rather than using England system when we have two parts, one from Brazil and another from Russia. Depending on what the customer choose, we could recommend this way. I think that this type of situation could increase the interest in studying by other countries. Regarding our experience, I think that in 2018, together with the association, the Lawyers Association of Russia, we created a program named Comparative Law. Not only it happens not only in our academy, but also in the Moscow University. And the main idea is that our students would study in Russia and Switzerland. In the case of this specific course, um, Switzerland is not a friendly jurisdiction for us anymore. We have some problems regarding this. We have this program. We have the methodology of how to make this type of program. And in 2023, we adapted this program for the study of the Chinese law. I believe that the program has a block dedicated to BRICS countries. And I invite my friends. I think it's important to include this in the resolution of the forum today. This proposal, with proposal to create courses about legal systems of each country of BRICS. Thank you very much for your attention. I think we should continue this discussion. And I want to remind you that in July we have the legal forum in St. Petersburg, and the section about the panel about legal education is important. Welcome to Russia. I would like to take the opportunity to invite you all for the legal forum in from 23 to 26 of July 2026. Is one of the biggest events, legal events, not only in Russia but in the world, in the whole world. It lasts 3 days. It's very intense, very interesting work, and every year the forum receives representatives of more than 100 countries. Thank you very much for your presentation.
Now, I would also like to go back to the presentation of the Professor De Paula, where she said we need to dedicate a lot of attention to the study of Roman law, which is a tradition for us, and it's very deeply influenced by Roman law, but there are other much more ancient traditions. And for today we have here our colleague from India, Yachin Thakur, president of the Bombay Bar Association, representing India. India is also one of the states with a lot of tradition in law, out of many fields, and a few hundreds of thousands of years older than Roman law. So the presentation, please.
Thank you, Nikita. Good afternoon. Esteemed colleagues, distinguished jurists, and ladies and gentlemen. First of all, a very big thank you to the organizers, and especially Dr. Bruno Barata, for allowing me to speak on the subject of legal education. It is an honor to be representing India in the Bombay Bar Association here in Brazil, where the BRICS Legal Forum first convened in 2014. In the 11 years since that inaugural gathering, the forum has grown into a symbol of legal cooperation among nations that are architects of a new multipolar world, and with each passing year, the forum is growing. Now we are not confined to BRICS, we are BRICS Plus. Collectively, I will call them BRICS nations. Today, the BRICS nations are no longer defined by their emergence, but by their influence. Together, we account for nearly half of the world's population, 40% of the global manufacturing output, and again at 40% a lion's share of the global GDP by purchasing power parity. We are now setting agendas in trade, technology, climate, and global governance. And yet, while our geopolitical roles have evolved, our legal education systems remain tethered to outdated frameworks often colonial in origin or Western in design. But let me emphasize that the sphere of legal education is not merely academic, it is more than that. And to quote Lord Denning, legal education is the foundation of justice. Without it, the law is merely a tool of power. Legal education shapes how rights are understood, how constitutions are interpreted, and how institutions evolve. For the BRICS nations, legal education must serve an additional mission, one that reflects our realities, supports our ambitions, arms us to face challenges, and equips our legal communities to lead in a changing world. It must evolve from passive transmission of doctrine to active engagement with the realities of our societies. It must equip lawyers not just to interpret the law, but to shape it, to respond to inequality, digital disruption, environmental crisis, and democratic transitions. However, these cannot simply remain a theoretical exercise. It must become a policy imperative, one that moves us from principle to practice and from aspiration to architecture. This new architecture of BRICS legal education must rest upon three foundational pillars. First, to localize legal knowledge by integrating indigenous and national legal traditions. Second, to globalize legal competence by preparing lawyers to operate across jurisdictions and technologies. And third, to democratize access, ensuring that profession reflects the diversity of our populations. These are not separate goals, but three dimensions of the same transformation. Let me begin with the first, localizing legal knowledge. For too long, legal systems across global south were inherited rather than imagined, drawn from colonial or Western blueprints that were never designed for our own social realities. These models have given us structure, yes, but not always relevance. They encouraged us to administer borrowed laws, not how to evolve our own. Courts and governments across BRICS have taken meaningful steps to reclaim this ability and recognize indigenous and customary legal traditions within formal legal frameworks. In India, constitutional provisions empower local governance bodies. Brazil's constitution protects indigenous land rights, and South Africa's legal system formally integrates customary law alongside constitutional principles. Legal education must mirror these developments. It should focus on teaching students not only to understand these incorporated traditions, but also to critically explore where else our legal systems can better reflect the diverse legal realities of our societies. Here are a few ways to make this a reality. Identify and integrate important customary law principles into core curriculum and not just electives. Invest in faculty development to build specialized knowledge and teaching capacity, and establish partnerships with grassroots legal and governance bodies to expose students to the gaps in legal doctrine or interpretation that must be addressed. The second pillar is globalizing legal competence in a connected and digital world. In this age, individuals and entities face legal issues that transcend national borders, from trade and technology to environmental protection and human rights. Legal education must prepare students not only to master domestic law, but to operate confidently across jurisdictions and emerging digital landscapes. Cross-border collaboration is no longer optional, it is essential. Lawyers need fluency in comparative legal frameworks and adapt at navigating complex international agreements, regulatory environments, and transnational dispute resolution mechanisms. To this end, curricula should emphasize comparative law, international arbitration, and digital law alongside traditional subjects. Bar association across BRICS can also collaborate to develop comparative law programs focused on the plural legal systems within our countries. Let me add, we at Bar Association of India have started moving in this direction. We may offer online certification course for lawyers across all jurisdictions in basic Indian laws required to be studied, which would be useful for cross-border contracts and dispute resolutions. Dr. Bruno mentioned about continuous legal education. We at Bombay Bar Association, as part of our continuous legal education initiative, hold courses every 2 months on different subjects. Like last month, we held a course to train and guide lawyers how to conduct international arbitrations. Next month, we are holding a course on intellectual property litigation. We also have regular advocacy training programs 3 times a year for all new entrants to the bar. We have recorded and released podcasts containing interviews with some of our great judges who were members of our associations. These
Excuse
have
me,
proved
2
to be-
minutes. 2 minutes.
Yes, it will be finished.
I am very strict.
For lawyers and law students, technology is a powerful enabler to this mission. Digital tools such as virtual court hearings, online legal research platforms, and cross-border knowledge-sharing networks are already transforming legal practice. Universities can contribute by developing partnerships with law schools and institutions across BRICS for student exchanges, joint research, and virtual moot courts. The third pillar is democratizing access. Even as we reform what is taught and how it is taught, we must ask who gets to learn. In India, the establishment of national law universities introduced innovative methods such as case analysis, etc. Similarly, in Russia, part-time and distance learning programs have expanded opportunities for students from working class backgrounds and remote areas. To further broaden access, legal education must embrace vernacular, that local language instruction, online platforms and flexible degree structures, curriculum, integrated legal aid clinics. These measures are tools of justice and inclusion. Democratizing access ensures that the legal profession reflects the diversity of our populations and that our legal systems serve all. In conclusion, legal education is not just about laws on paper, it is about the people, cultures, and futures those laws could teach. We stand at a crossroads where we have the rare chance to redefine what justice means for billions across BRICS nations. As Charles Hamilton Houston famously said, a lawyer is either a social engineer or a parasite to the society. The future of legal education in the BRICS era calls on us to be bold social engineers. The path ahead is demanding, but the opportunity to lead a new era of justice and legal excellence is ours to seize. Thank you very much.
Thank you very much, dear professor. To be honest, I would like to say that I agree with every word of your presentation. И я думаю, что те, которые были обозначены, они разделяются всеми нами.
Bom, já tendo apresentado e são compartilhados, they are all shared, all the values shared here are supported by the legal community of the BRICS countries, and I think it's really important to say that it's not just about tomorrow, just tomorrow. It is about what we can do today in terms of cooperation and of perfecting legal education in the BRICS countries. There's a famous Russian sentence that says, there's no limit for the ideal. We should always try to improve and reach it. Now I'd like to give the floor to Dr. Erman Arifai, who represents the United Arab Emirates, which is one of the main world pedagogical hubs, where all the conditions were established for a inclusive knowledge too. The floor is yours.
Ladies and gentlemen, I'm glad to be here today in this session as a speaker in this important forum. Before starting my subject, I would like to introduce myself. My name is Iman Al-Rifai, lawyer and a private notary, the president of the higher institution of the legal training, and the board member of the United Arab Emirates Association of Lawyers. Today I would represent the procedures and the steps that law graduates follow after completing their studies at the College of Law. So after completing their academic studies, they move to a new stage in their professional journey, where they choose the path of the best matches of their goals and skills. Some will join the government or private institution as a legal advisor, and others will choose to be a lawyer. For those who will choose to become a lawyer, the next step to join the next step, they should join the lawyer training program at the Judicial Institute. This program will take 1 full year, 6 months, divided to 6 months, theoretical and practical. The first 6 months of the theoretical study, trainees learn about the legal procedures. They also introduced legislation that were not a part of their studies, such as artificial intelligence and digital currencies, to stay update with the latest legislation development. Followed by the second 6 months of the practical training in law firm. During this practical stage, they attend court hearing with the lawyer they train with, writing a legal memorandum, submitting application through the electronic court system, and build communication skills. They also gain important practical skills under the supervision of the lawyer trained with. After completing this stage, they take the legal oath before the competent authority and working as a junior lawyer at the primary and appeal court. Also, I would like to add to Mr. Nikita's speech that the Higher Institute for Legal Training will organize with the Emirates Lawyer Association a training workshop will announce them in the languages of the BRICS countries, with the translation provided for the participants. Finally, the law is not just a job. It is a promise to support truth, fairness, and human dignity. Law is the voice of justice that speaks up when silence is not an option. And thank you for your attention.
Thank you.
Thank you very much.
Muito obrigado.
очень рады, то, что
The United Emirates joined BRICS last year, and once again, I'm going to tell that the
огромные возможности традиции.
where a lot of tradition come together, and it's a great power for studying and create, besides academics contacts, professional contacts. I would like to give the floor to Professor Billy Hancharo, which represents one of the biggest law schools of Russia, State Academy of Moscow, named in honor of the jurist Alexei Kutafor. Is a big academy with several areas of study and programs and researches, which are very big. I think the Professor Sanazara can talk to us about the most interesting news of his university. Thank you, dear colleagues. Good afternoon. I greet all of you in this very important forum of international dialogue. I represent, as mentioned, the law school of the law university, State Law University of Moscow. We are a very big university at the country. We are leaders in several areas. I'd like to tell you that the forum is organized by associations and bar associations of BRICS countries, and we have our association present the Brazilian Bar Association. The position of our association of lawyers is linked to our university. Our dean was one of the presidents of the association. He was one of the founders, together with the founder of our university. He took part in our association. At that time, it was clear that it was necessary to raise the question about the union of the law universities. We created it in 2008, Organization of Law Education, that reunites the universities of the country. And I would like to propose to our final declaration that we are assessing the possibility of creating group of organization of the universities in BRICS, law schools in BRICS. We are the representatives of the legal communities and the universities. We speak the same language. Despite representing countries with different legal systems, we can understand each other very well. We can see this in our conversation. It's very important. This type of association could be a platform for preparing a methodology, a common methodology for education, despite the difference between the legal systems. Our systems are evolving, they change, it's normal, but the methodology can be harmonized. And the methodology of teaching, the pedagogical methodology can be harmonized, aligned. I will talk a little bit about the legal education in Russia. Our colleagues didn't go very deep. I will share my experience with you. Our pedagogical law system. We are refusing the Bologna system. We are adopting a national systems, a basic education and specialization. And also, we have a great amount of tourists in the market. We are creating limitations to new courses and students. We are limiting the numbers of students. We are doing this because our Ministry of Education, we are trying to decrease the interest in law in Russia. We have a lot of tourists, but few of them are good. Few are few good lawyers. We are talking here with representatives of few universities that train good jurists. It's important to consolidate our position in this regard and create a methodology of education, share these practices, and share in the level of other BRICS universities. When we talk about the challenge of the legal system in Russia, we have a lot of things in common with the colleagues of BRICS. We have technological challenges in the first place, the digitalization of the law, artificial intelligence. It's a challenge for education. It requires to reevaluate our approach to the legal system, the education system. As a university professor, I always face the use of artificial intelligence in my student papers. We are learning to distinguish a thorough job and a paper done by artificial intelligence. Many times the prompt, when the students update my paper, it mechanically changes the year of final paper that was earlier mentioned, despite this paper had been written 5 years ago. We understand this as of members of evaluating bands. They can't trick us. We have to control this. We have to moderate the system. I'll talk a little bit about the experience of our university, the Moscow University. We are using innovative technologies, pedagogical innovative technologies. We create a innovation project. And we created competence skill centers. You understand what is this and why it's an innovation. We created something as geological law, ecological law, cyber law, sustainable development law. They are centers that consolidate different skills in a interdisciplinarity level. We can include institutes, colleges, companies, and a new practice for us, the creation of what we call green fields. We created a superior law school, we call it Greenfield. It would be a platform of development of new competences. We have a course of automation of legal proceedings. We put together the medical school. We created things on medical law. We have 4 already done. One of the centers is Russia and China, and I represented studies of intellectual law in the field of agriculture and the information technology. We make bilateral studies of exchange. We don't have the center Russian Brazilian, but we'll correct this after this forum. And last, I would like to talk that it's necessary to to approach the standard of the legal education in our BRICS countries, and also in platforms, permanent platforms that can be organized based on an association of legal universities of BRICS through organization of conferences, work groups between professors and the students. I think it would be interesting for us. I invite all of you to cooperate in this area. Thank you for your attention. It's very. Let's discuss. In the future, we are going to discuss all these suggestions. You are right. Without our cooperation, without direct channels for communication, it's impossible to establish a good legal education. I would like to hear two speakers. My colleague from South Africa, from the Association of African People. I would like to give the floor. My knowledge, it happened in Johannesburg, in South Africa, in the level of, in the final comments, I will finish this session. Muito obrigada. Eu vou ficar nos protocolos observados. Antes de
the system back to just play quickly a small clip of a video that shows how, as African people, in the early 1800s, we're conducting ourselves with our law without the colonial power. I will ask for that video clip to be played. It's a pity it does not have sound, but to tell you, this is a case where there was a dispute on the twins, on who must be the heir. Due to the culture now, if you see these old men who are seated there, this is the king, these are the people, that is the complainant, the other one. These are the people who are assisting the king and the chief to arrive to a decision. The point is that before they arrive, we were having our own laws. These are the men of the community who are waiting for the court to start. And this was back in the days. So now, if you see, they have started, and the guy who is standing there speaking acts as a prosecutor and is asking questions that this one must stand up as the complainant, and he's asking him the questions. But thank you very much. But the point that I wanted to depict is that before we were colonized, we were having our own laws in Africa that we were practicing, and our people were living in harmony without the Western laws. Then to address myself on the topic of the day on decolonization of the legal education in Global South, the decolonization of legal education in the Global South is a very critical question of transformation. It seeks to fundamentally reshape our law schools, curricula, and the pedagogy, moving away from the residual dominance of the Western powers, particularly the English and the Roman Dutch law, and the legal thoughts and institutions. We must create a system that is relevant, inclusive, and grounded in the unique historical and cultural and socio-economic realities of the nations that make up the Global South. As the Secretary General of the National Association of Democratic Lawyers, I would say, as the progressive legal body, we addressed this issue at our own conference in 2016 on the decolonization is not just mere about changing the laws, and it's about transforming the culture, structure, and the purpose of the legal system to better serve the needs and aspirations of South African people. The conference participants highlighted how South African law, particularly common law and statutes, was inherited from the colonial powers and has often marginalized indigenous legal traditions. They emphasized the need to recognize and restore customary law as a legitimate and equal source of justice. The transformation of legal education is therefore a key component in transforming both the law and the justice system. Key components of decolonization, one would be the curricular reform. The central task is to shift the legal curriculum away from an exclusive reliance on Eurocentric and positivist traditions, such as Roman Dutch or English common law, which were imposed during colonialism. These include inclusion of indigenous and customary law, integrating the study of living indigenous law and local legal traditions, treating them as valid and primary sources of law, not mere secondary or anthropological subjects. Before the imposition of Roman Dutch law, our people lived in harmony under the system that maintained order and resolved disputes, both civil and criminal. The classic Xhosa narrative of Ityala Mawele, the one we just showed, clearly depicts how our ancestors, through their kings, chiefs, and headmen, administered justice rooted on the principles of Ubuntu, uniting communities and preserving social balance. On the contextual and history, emphasizing the colonial history of law and how it was used as a tool of oppression and social control, students must critically engage with the origins of biases embedded in seemingly neutral legal concept and rules. The epistemic justice, introducing diverse legal philosophies, theories, and scholars from the global south to challenge the Western epistemic dominance and foster new locally relevant knowledge. 2, the pedagogy and methodology. Decolonization also concerns how law is taught and learned, from banking to dialogical education, moving away from banking model of education where teachers deposit knowledge into passive students towards critical and dialogical pedagogy as an advocate by Paula Freire. The interdisciplinary learning, encouraging law students to connect legal studies with history, sociology, politics, and economics to better understand law's real-world social impact on the language, confronting the dominance of colonial languages such as English, French, and Portuguese, etc., as the sole medium of instruction and research. Greater inclusion of indigenous languages in legal discourse is essential to make justice accessible and meaningful. On institutional transformation, decolonization also demands transformation of law faculties and legal profession itself. Staff transformation, addressing racial and gender imbalances in academic and professional hierarchies, and recruiting faculty committed to decolonial scholarships and research focus, reorienting research priorities towards local challenges, community justice, and development of local jurisprudence. Then on challenges as I sit down, Chair. On academic resistance, some academics invest in Eurocentric frameworks, resist change due to habit, fear of lowered standards, or lack of exposure to indigenous methodologies. On structural inertia, law remains deeply tied to national legal and political framework. Meaningful curricular reform may require parallel changes in the country's broader legal systems, including formal recognition of customary law. Language and resources, a shortage of legal terminology, textbooks, and case law in indigenous languages limits integration.
2 minutes.
Accessible.
2 minutes.
As I sit down, thanks, Chair. The global standard and the trap, many institutions fear that deviation from Western models will reduce global competitiveness, reinforcing the colonial hierarchy and knowledge. Now, in conclusion, in essence, decolonization of legal education means reforming our legal system to reflect indigenous knowledge, post-colonial consciousness, and social justice. We seek decolonization because colonial legal education is still largely Eurocentric and language exclusive, continues to alienate and marginalize. Our indigenous systems were not primitive. They were sophisticated, communal, and guided by principles of Ubuntu and equity. Let me end there. Thank you.
Thank you very much. Дорогие коллеги,
now we're going to discuss these topics on the coffee break, but as I was introduced as the moderator, I am going to close this session. And I'm going to speak from here. I'll present a few theses, and I'd like to also respond to myself a question. Why do I like BRICS? Well, in my opinion, there are some topics that I need to call your attention to. First of all, BRICS is a new way of cooperating between the states. It is fully different from the international organizations and of these integrational blocks. What's new about this way of cooperating? The participation in BRICS is not non-binding at all. These are very flexible ways to relate to each other. And it's very important that politicians, jurists, and economists all talk about it. It's very important not to bring into BRICS what's not efficient in the international organization's environment. You don't need to create a secretariat, a permanent body, and yet position BRICS in the perspective of the ways of relationships. Every year, a country that receives the BRICS receives a series of events, from summits with leaders, as well as meetings of ministers, the legal forum, and projecting that for the legal education field, I didn't support the idea of an association of the BRICS University. I think it's really bureaucratic. It's very traditional in terms of the forms of relationship. But the most flexible formats that we can offer, like summer schools or programs, study programs for adults, they could be excellent platforms for, like I said, the example of the UAE, because this it's far from everyone. It's far from Brazil, from China, and from Russia. It could be online courses in platforms from some specific countries in BRICS, and it still doesn't exist. But we could start perhaps this initiative, and we offer our support to that. So I wouldn't like to include in the declaration the idea of the Association of Legal Universities in BRICS, but I would focus more on the principle of legal education, which is in full harmony with the BRICS principles of flexibility, mobility, pluralism, and many different ways to relate. That is the BRICS, because when we create an association, we're going to discuss about for a long time, based on what system we will legalize it, how it's going to be managed, how it's going to be funded, etc., etc. So let us not waste time on that. I think that that's the biggest power of BRICS. We don't need to spend time with the creation of secretariats and organizations, permanent bodies. Instead, we can find concrete results. With regards to the education more strictly, how can we study the BRICS? Well, we can study the legal systems of the BRICS countries. We discussed that a lot. We're not very familiar with everything, so anything that would allow us to get to know each other better, we should take advantage of. We should create summer camps or summer schools, just like it was done with Minas Gerais or the UAE, but also permanently in all the member countries of BRICS. I remember last year, our main forum was preceded by a youth forum where there was a lot of participants from the BRICS countries. Like Professor Zaitsev mentioned, they met and they discussed things, and we were able to also study the cooperation of following up on legal processes in the BRICS environment. That is a very complex thing, but one thing that I wasn't mentioned a lot, we talked a lot about sustainable development and arbitration, but we didn't talk about the payment relationships in the BRICS environment, and that is a very pertinent topic with regards to the sanctions when talking about boycotts and companies that were removed from the SWIFT system, which is a payment financial structure. And I think that this is a very prominent problem that interferes with our development, because it's very difficult to make payments between our countries, almost impossible sometimes. So this needs to be discussed, and Russia is outside of SWIFT today. Tomorrow, any other country might be excluded as well. So we must be ready for it.
Lastly, I like to mention that I like it a lot. Something that I really like it. We had some very good reports, speakers, but today we talked about this digitalization, and it was very comfortable for me to moderate, because lately all the events about education starts talking about digitalization. It's important, but let's think about, is it going to change our profession? My question is categorical. No, the essence of our professions will not be changed. As the professor from India mentioned, the legal relationship is about the relationship between people. So digitalization, what does it change? It accelerates it. We can use artificial intelligence, technology, computational technology to develop our profession, but it will not change the essence of our profession, which has existed for million, thousands of years. I like the panel today because all the speakers discuss about very important problems on the development of education, of the legal education. But they are problems so important as the digitalization, maybe even more important. I would like to thank all the speakers, all who are here for the second day. So complex report. I would like to thank Professor Bruno for having organized this panel, which is full of content in this wonderful city of Rio de Janeiro. Following a Russian tradition, I will propose that we take a picture together I see you at the coffee break.
So sorry, because we have all picture together as yeah. Let's take it.
Stand up, right? Yeah.
Em prosseguimento aos trabalhos do 10º
Continuing the 10th Legal Forum in BRICS, we will take a swap to ensure the flight times of the speakers. We will start with the conference Legal Transformation and Multilateral Cooperation, Fragments of the Brazilian View for BRICS, and Challenges for the Future, with Dr. Marcelo Eictpugliese. And then we will have the panel number 6 with the topic Innovation and Intellectual Property in BRICS. As a moderator, we would like to invite the Vice Coordinator of the Executive Commission of the Legal Forum of BRICS, CFOAB, Dr. Gaia Schneider. As the speakers, we invite the professor of the Department of International Private Law, Benjamin Ksarnazarov, director of the Center of Legal Support to the External Economic Activity, Substitution of Imports, and Industrial Development from the University of State Law in Moscow. And we invite the president in the Commission of Intellectual Property from the Russian Bar Association, Dr. Vladimir Lopatin.
Nada. Não entendi.
Extra do Dr. Marcelo.
We are going to start with the conference of Dr. Marcelo Eictpugliese. Please, Dr. Marcelo. I would like to take your seat so we can start with the lecture of Dr. Marcelo. Good afternoon, everyone. I would like to thank you the invitation made by the Federal Council of the Brazilian Bar Association. I would like to thank our president, Beth Simonetti. I would also like to thank Francisco Apontoneto and also my dear friend Rodrigo Farias. I know the effort that the Brazilian Bar Association put to organize this 10th forum. I know how difficult it is to organize such a big event with a different countries. Welcome to Rio de Janeiro, in a very special moment that Brazil, by the end of the year, is the president is taking the temporary presidency of BRICS. So it's an honor to have you here in this opportunity. I will try to. At the beginning, you had the participation of our Ministry of Justice, Professor Ricardo Lewandowski. I will give you the perception respecting. I'm not from the Ministry of Foreign Affairs, but from the perspective, the Brazilian perspective, under the point of view of the office that I hold, the chair. It's the body that makes the direct assistance of the president, and not only regarding legal, but also all the actions that the Brazilian government emphasizing, put a special attention to the relation that the Brazilian government, President Lula, has with the countries that are part of the BRICS, which is not exactly an economic bloc, but it's increasingly looking for convergence, a consensus. BRICS nowadays has a very important role in the new geopolitics of the multi visions, so we can surpass this unilateral vision that is bad for the development of the world, especially of the respective countries. There is no doubt that this forum, which is in its 10th edition, has an excellent channel for articulation of proposals, synergies, and this alignment is prioritizing the harmony of the legal systems. We can talk about the economic development and integration if of the legal area we don't start thinking about ways of better integration. When we address integration in BRICS, we try to run away from the Eurocentrism and the American view of that models, the Roman German model or the common law model as the only possibilities that we have to face the commercial section. The diplomacy is very centered in this vision, the Eurocentric vision and American vision.
So we have to know how to respect our individualizations, our differences, and every complexity, every legal system in every country, whether it is in the economic vision or religious vision, and trying to find consensus and ways to integrate. In 2025, it is inarguable that we have a higher challenge now because BRICS this year starts having a much broader vision. From the founders of the BRICS, we now have the participation of new players, significant players, that also start representing 50% of the world population. We have reached 46% of the world population, over 3.7 billion inhabitants in our countries, and approximately 36 to 37% of the global GDP. So we are a huge manufacturing power that produces economic development, and why not a revolution in the concept of interaction and integration in a world level. There's a lot of things that brings us together, but there's also a lot of challenges ahead of us. So we have a lot of convergences, but we cannot forget the fact that we have a lot of asymmetries. Economic asymmetries, social asymmetries, as well as political asymmetries. And these asymmetries perhaps are the concern that President Lula always mentions, that to find this multicultural, multi-economic, and multi-individual perspective that breaks this plurality, which is our greatest fuel. From the individual experiences, we might be able to construct instruments of economic development and of consensus. It is important to highlight that perhaps Minister Lewandowski has already mentioned that President Lula and the presidency of BRICS in 2025, Brazil's idea in our mandate, we will now move it over to the colleagues in South Africa, but still finalizing the few month and a half that we have left, President Lula has tried to consolidate a few axes that in this presidency seem to be fundamental. First of all, the cooperation in global health. This is something that we in the legal area have a huge challenge ahead of us. When we talk about having a concern in combating social determined diseases and neglected tropical diseases, we cannot forget that not long ago we experienced COVID-19. And this crisis demonstrated how much we need to think more connectedly, not only to confront technology and research and health, but also the whole logistics necessary to face these challenges. And how much we need to think about a logistical distribution that is capable of tackling these pandemic problems that might occur, and probably more frequently in a lower time frame. So if you get the last 30 years, the endemic and pandemic crises and numbers have increased a lot, and that's the tendency. We have a larger population. It's harder to contain crises, and it's really important. The experience of China and India, we could have many good lessons learned from these countries who nowadays have a logistic and technological development that is really advanced in health, and we can learn from them and integrate these solutions. There's also trade, investment, and finance challenges. I was watching the educational conference. We have a huge investments to make in normatives to come out of these dependence on the dollar and move away from the dependence of the SWIFT system, and how we can create commercial transaction mechanisms that will remove us from this dependency on the North American currency. President Lula has been talking about that a lot to try to improve the transaction with national currencies, real, the Chinese, the Indian, and the Russian currencies, and all the countries that are parts of BRICS is very important for us to have a better trade fluidity, and it improves our economic architecture in that sense. It is important to highlight then the role of the BRICS Development Bank, led by former President Dilma Rousseff, and how important this could be to foster new investment and new ways of visualization. We have experience, of course, as you know, at the PIX, which is a currency circulation system. It's practically a digital currency. You are here, if you live in Brazil, you don't see currency being circulated in cash. You only use PIX, or most people only use PIX. And we have colleagues here in BRICS who have very significant experiences as well with these digital currencies that we need to stimulate in terms of development. There's another important issue, which is how can we do sustainable economic development? How do we develop our economies and our societies individually without damaging the environment and having a concern for the continuity of our environment so that it's ecologically sustainable? You are invited. We're going to have in November the summit of the COP30 here in Belém do Pará, a state which is sort of the doorway to the Brazilian Amazon. We're going to discuss ways for us to sort of reconcile respect to the environment with economic development. And it's really important because we have a normative world to tackle. The legal area needs to create safety and security so that we can talk about sustainable economic development, and so that we can get all of these great reserves that we have and transform them, maintain them, as well as generate economic growth with it. So there is production arrangements using the energy matrix, the ways that we have, for example, the carbon market is a wonderful project, but we do need to build normative systems that can interact so that the legal security can be assured in these transactions. The highest difficulty is how to certify the carbon credits nowadays, and how do we do this transaction reliably, that this generates a market like Bitcoin today, because a lot of the times there's no safety and security in this certification. So we need to create a tool set that allows an economic transaction for the carbon markets to stimulate these transactions. And Brazil is deeply concerned with this. We approved the the domestic carbon markets. The Ministry of Finance here in Brazil and the Ministry of the Environment have structured specific secretariats to rate the infra-legal aspects, but we still need to dialogue a lot more between the countries so that we can build a more adequate transnational markets for carbon. It is also important to mention, and that President Lula mentioned during his presidency in BRICS, of this international governance of AI. Everybody knows how important it is to have technological development and how AI is important, but it is very important that we start discussing, which was talked about the previous panel, to build consensus, regulatory consensus, so that we can ensure technological development, ensure an AI that could be like generative but can service the economic gaps, but that we also worry about the labor market, that we work towards social development so that to be a transformation, so that there isn't a concentration of resources in the hands of very few, but instead using AI to ensure better employment and more quality of life for the entire society, not only at a national level, but also internationally too. It is important to highlight, and that is the concern of the Brazilian government, this multilateral peace and security architecture. I think that this is important to highlight in the BRICS scenario, even though we know that here, each of our colleagues here are undergoing instability moments from the peace, social peace aspects, but it's important for us to try to find, through consensus and through dialogue, solutions that are peaceful and ways to solve our conflicts that are not bellicose. It's important for us to say, and Lula mentioned this too, the most important fight is the fight against hunger and against inequality, and we can't foster conflicts, armed conflicts, to become the center of a problem when we are actually in need of distributing wealth and revenue so that the world population can live a more dignified life. And we in the legal sector have this role. When diplomacy and law cannot solve, then there is a problem. So we got to stop to think about it and find solutions, whether it's in the diplomatic field or in the legal field, to overcome such adversities. It is important to mention also that this institutional development of these amplified BRICS also makes it so that we have more responsibility and that we can also, in fact, perfect our processes, procedures, and that we can make so that these new partners integrate and participate more plurally, more effectively, and that we can, as a result, bring solutions that are more interesting for this group that is more growing stronger, more representational every day. I'd also like to highlight a few important aspects in terms of normative advances. We signed, the chiefs of states signed the Declaration of Rio de Janeiro, which incorporated development, sustainable development and trade, and mechanisms with AI governance and climate change. It is important to highlight here that we all signed this declaration, and we signed a commitment to create a climate transition fund, and also for the forests. It's important to have this concern of how important, how interesting this is. It's also a moment to reaffirm the Development Bank of BRICS, which started employing new compliance rules, environmental standards, and social and ESG metrics to analyze projects that are deeply connected to best practices internationally. So beyond the fund, the arrangement that we created to sort of get away from that IMF logic that suffocates the global south, and we are sort of at the moment hostages of this situation. This movement was made by China, Brazil, Russia, and Africa and South Africa to bring 100 billion to create this arrangement to try to sort of escape this dominance of the IMF. This makes it so that we have solutions to strengthen and respond to certain currency and tax crises in the short term, so that we can help each other and bring a better sustainability level at an economic level for the BRICS countries. It is important to also highlight the adoption of this signed memorandum of political cooperation between legal entities and jurisdictions, fostering this exchange of decisions and dialogue between legal systems in arbitration, protection to investment, regulatory innovation, and legal security in international trade. I would like to bring a point that Brazil has an internal council at the national level, a social and economic sustainable development council, where we dialogue with social security, civil society, and with the academia and other sectors. And we received a pre-project of reforming the new legislative international private legislative framework. We know how hard it is to try to reconcile the trade legislation for each of these countries with the Brazilian law. It is very difficult to try to find this integration a lot of the times. I had an experience recently working at Petrobras, which is our oil state-owned company, and we know that it's very difficult to try to, for example, try to make a purchase internationally. You try to find, for example, an oil rig that was built in Korea or in Singapore. How do you create this normative framework to avoid conflicts between the person that the company that's building, the company that will operate, what legislation will be used in case of disputes. Even though there is an option for an arbitration, what is the legislation that will be used as a reference? And this is an important dialogue to have to try to build solutions that aren't as sort of individualistic, not mention like the use of New York law or London legislation. Instead, being brave enough to try to use legislations that belong to the nations that are part of the BRICS to try to find solutions that sort of escape this Eurocentric global north standard to resolve disputes, which a lot of the times reduces the competitiveness that we have and also the areas in which we can our attorneys can work, the attorneys coming from the BRICS countries, because when you use the London or the New York legislation, you remove all of the trained professionals that know their legislations of their own countries to follow the English or United States legislation, removing thus the participation of such players. It's important to highlight also that in the internal scenario, we were very careful in the management in the Lula administration since 2023 to work with the perfecting legislations to stimulate the green economy, the funding of sustainable infrastructure projects, and also strengthening public-private partnerships.
It's very important that you be aware that Brazil today is prepared to receive investments from countries and have them participating here, acting here with us in this integration project. Less than 15 days ago, President Lula issued a decree that improves the immigration process regarding visa, working visa, and academic visa, which facilitates integration between people, between countries, and the focus of the president is to prioritize this accessibility of the colleagues from BRICS countries to act here in Brazil. This reciprocity we are stimulating to permit that the integration between people and professionals occur in a very interesting way. For you to have an idea, we invested in infrastructure in the last two years, from 2023 2025, more than 270 billion of reais. 277 billion of dollars. It's very below the 4%, which is the ideal number. But if you compare the last 10 years, we are resuming the investments in Brazil. From these values, almost 102 billions is in the electricity area, 89 billions in the transport area, and 40 billions in the SWOT area. The SWOT area open. We had a concentrated market. Now we open for public-private partnerships. It's an absurd market in the telecommunication area, which is a very important area to be highlighted. It's important to mention that investment in Brazil in the field of digital economy. Now we have provisional, let's say, an executive order, which is for immediate application for data centers. Brazil has a very big energetic matrix, sustainable energetic matrix. So energy and water, which are two important sources for data centers. And we have an investment, a very big investment in the tax area. Tax benefits to bring investments to Brazil. It's important to think as BRICS that it's not enough to have countries investing in data center if we don't invest in technology in logistics for this data to to run a worldwide environment. It's important to have this concern because you have to think about other path of this data flow of information. If we look at the geopolitics of these logistics of data, it still depends a lot on Europe and the US. We need to create new paths for this migration of data and information occur in a more interesting way. I would also like to highlight that Brazil is very worried about logistic visions, trans-ocean logistic visions. We have we look a lot to Atlantic, but we also have to look at to Pacific. Ministers, Simone Tebet and our ministers, we have thought about constructing. It could be through trainways or riverways, access to technology and information to be more close to countries as India, China, Southeast Asia, Middle East, to construct these routes of great integration. Uh, I I still have a lot of things to say, but I would like to give some challenge, stimulate you to think as tourists and formulate of rules and future normative environments. Think about a greater integration, legal integration, that we could have a perspective of problems, this fragmentation, which is natural when we have very different legal systems, looking for a consensus, not losing the sovereignty, which is very important in a moment that force through wrong tax system trying to suffocate the growth of the BRICS. The concern about diversity of the legal systems. BRICS has different legal systems. We have civil law, common law, Sharia, hybrid, and different federative arrangements in judicialization. We have to identify these minimum points of convergence, and we have to try to these questions to look for more simpler solutions. We have to, regarding visa, as I mentioned, we should focus how to improve the relationship between persons, trying to identify single issues, not trying the hegemony of one in prejudice of the other, trying a synchronization, a legal normative synchronization. It's a very important way. Another issue that we have to face is how we make this integration. Now I'm talking specifically about those who work in the legal area. Each system has its own complexity regarding the exercise of the law and how we can look for this convergence. I have different symmetries. Brazil has institutional maturity. Our class council, Brazil is very mature regarding the participation of the Brazilian Bar Association here, that the Federal Council of the Brazilian Bar Association is mentioned in the Constitution. It has the judicial review, the concentrated judicial review, which is a sui generis model, which shows the maturity, the development of the participation of the class council of the Brazilian lawyers. It's important to look for this consensus. It's a problem. How can we make a professional that works in Brazil to work in other countries that that are part of the BRICS, so that you can participate and act this way? Maybe we should look for mechanisms of consensus to deal with the international private law, we have to advance. It can be a dichotomy. Only my legislation is worth. We have to have systems, maybe we'll have to have systems and contracts based on plurinational systems. We are not a European community. Maybe we would have to create in the private contracts, we would have the legislation, the Russian legislation, Indian legislation, Brazilian legislation, and South Africa, integrate a specific question and would have constitutional maturity to face it. And regarding the market reservations, when sometimes I don't want the contract is going to be entering the Brazilian territory. So the Brazilian law is applicable. Maybe we have to have a dialogue to integrate plurinational mechanisms for that to happen in a synchronous way. It's important that we have an agenda, a concrete agenda of emergent topics regarding regulation gaps. The regulation of artificial intelligence, the regulation of cryptocurrencies, cybersecurity, the environmental civil liability. It must be in BRICS agenda. You are leading these legal discussions. Look for a common agenda, not in the only in the academics discussion, but creating regulation frameworks to advance with BRICS and make it stronger. The absence of regulations is undoubtedly, it requires quick answers, inclusive answers, which have the participation of this heterogeneous vision, which is BRICS, and that could also, we can't forget that our concern is the social development and the inequalities that we have in our countries. We have to have maturity to face these external pressures and these sovereignty dilemmas. This role, this anti-hegemonic role, and this increasing assertivity of Russia, India, it creates tension. It creates economic tensions, commercial tensions, but we have to be mature enough to construct this dialogue and face the Western powers. The Brazilian Supreme Court is being sanctioned. Brazilian government is being sanctioned. Russia is being sanctioned. We have to be mature to have diplomatic dialogues, trying to find to overcome these issues. It only happens when we stimulate our commerce, our integration, when we depend less on the American and European powers, and to construct these situations. Brazilian government has suggested, just to finish my speech, Brazilian government has suggested some issues. First of all, the creation of normative observer. It's very important that in the level of this forum we can potentialize this observer to continuous monitoring, so that the normative problems not only discussed when we are here in the forum. It's important that we monitor it constantly, and these problems are solved faster. Regarding the visa, working visa, if we have it's solved quicker in face of tension, sanction, we can have faster answers. It's important that the forum is concerned about a greater integration between Supreme Courts, arbitration tribunal, the lawyers. If you create channels of greater integration, and this forum can have the role of a conductor, we can together with normative solutions, we can find dispute resolutions. We can have answers in a more integrated way.
And also, I think we need to stimulate a soft law production beyond the normative changes and anything else. We should work on good practices, booklets, recommendations, technical protocols, and a better translation of the internal normative system for our colleagues. People need to understand how each country functions. Sometimes it's difficult to find practical guidelines for businessmen who want to invest in a specific country. How can they understand the legislation of such countries? It's really complex. They can't have an easy to access recommendation for these kinds of things. So this forum can become a great fostering agent and stimulator of a normative and regulatory development, as well as the facilitation and simplification of the understanding of national legislation, so that we can allow a professional integration in economical and business integration, every growing and more. Lula is very happy to receive you here, our president, and I want to thank you to thank the Brazilian Bar Association Federal Council for organizing this event. We are sure that BRICS, even though there was a lot of doubt that we would be able to integrate, we're able to not only integrate but also amplify and guarantee that we will change the flow of the social and economic relationship. In the name of the Brazilian government, I wanted to thank you for the integration. Thank you very much. Dr. Marcelo, in the name of Beto Simonetti, the president, and Bruno Barata, and many others, my partners in the organization of the forum, I want to thank you very much. And this is music to our ears when we say, let's remove this Anglican vision of what we're doing. Let's do our own way. And you bring three words, which are convergence and cooperation. I was in a conference now with Dr. Margaret Dalcomo from Fiocruz in the Longevity Forum. She brought a very important communication that Brazilian researchers have already told us that we have a 48% chances of having a new pandemic in the next few years. So when you look at a globalized health cooperation, this brings us comfort. When you say that we're trying to find, through legal safety and security, in international governance of data and artificial intelligence and the structure for this data to be able to circulate, this also brings us peace. So knowing that the Brazilian government is leading us towards these great achievements and that they want just more effective small actions is the sort of lightness that we need to find in business. The public-private partnerships, I think that Brazil is going to have a sanitation boom in the next few years, for example, and the energy and climate change, also the so-called sustainability. So very good to know that Brazilian government is concerned, and the Brazilian Bar Association is at your disposal through our international relationships to be part of this observatory created by the federal government. We're always open to dialogue and cooperation with the Republic. Thank you very much. I know that you have a flight to catch, so please go right ahead. You're invited. You can leave the stage. Now we're going to talk about innovation and intellectual property in BRICS, I'd like to invite to talk about the protection of intellectual property in the context of economic restriction our friend Benjamin Shagnestov. He's a professor at the director of the Center of Legal Support to External Activity and Substitution of Imports and Industrial Development in the State Law University of Moscow.
Hello, everybody.
Olá a todos. Eu posso podem colocar minha apresentação, por favor?
Уважаемые коллеги,
Dear colleagues, I would like to talk about the problem of intellectual property protection in the context of economic restrictions and the problem that the Russian Federation is facing in this context when we just talk about different categories of intellectual properties. I wanted to start from the fact that intellectual property for all of our countries, members of BRICS, has always tried to distribute knowledge and technologies in the world in a friendship context to create a single space for the production of new knowledge, new technology, new development. And I would like to highlight that, in our opinion, in this area, it's inadmissible to discuss the limitations motivated by political decisions, because regardless of our policy, we should never forget that recent events like COVID-19, when there was a pandemic, this was a tragic infection that took the lives of many people, and the states fought side by side against COVID with tools in the intellectual property area as well. I remember that during this period, we, not only us, but many states modernized their legislations. New laws were approved in our, for example, civil code, which, in case of extreme need to ensure the life and the health of the people, even without a license, from a patent owner, a patent could be sort of breached in order to enable the distribution of medication, which would help combat COVID-19, like vaccines, individual protection equipment. And the world was unanimous. Everybody understood that this was the right way to deal with this situation, and intellectual property would be the adequate mechanism to combat the consequences of COVID-19. In this context, we support the initiative of IP BRICS, which proposes a unity between patent issuing agencies in the environment of BRICS. The State Legal University of Moscow is also supporting this. We dedicate a lot of attention to these problems. Recently, we launched a book about intellectual property in BRICS. We did it autonomously, but would like to cooperate with other universities. We're open for cooperation in research, comparative studies, because this is really important. Because I was the editor and our president of the intellectual rights court. She just retired, but she was a judge. And going back now to the problem of the integration of intellectual rights in education, I would like to highlight that we're creating centers to defend intellectual property and exchange experiences. We created a bilateral center with China where we exchange experiences. We develop special regimes for companies. For example, I'd like to mention Marcelo, which in his important presentation has said how important it is to create special regimes for establishing payments and the transactions of goods. So a multilateral and bilateral work has to be done in this area. We're doing this with China. We need to work with Brazil, with you and other colleagues that are representing Brazil in BRICS. That's really important to us. Moving on to the problem, I would like to highlight that the Russian Federation understands these sanctions as unilateral actions from certain states, and we don't think that they are applicable for Russian context. They're not according to the international rules. I've mentioned, for example, the UN Statute Article 41, which discusses the stop of economic relationships between countries, which should be done with a Security Council, but this does not happen with Russia. It was just unilateral decisions from some countries like the European Union, and international agreements in terms of intellectual property are non-declaratory documents, but they are basis for legal agreements in cooperation. For example, the Madrid system, they have manuals in international agreements, and there is no mention about the possibility of removing intellectual property rights because of political reasons. And this is taking place according to our perspective. They are violating international agreements, and now we have really complex challenges with our jurists and the compliance people. We say that the list of competencies should be formulated, and we try to do so in our universities for mitigating risks in the intellectual property areas, especially with sanctions. This area was also subject of the sanctions. We always believed that it wouldn't take place, but we saw some limitations because of personal reasons and sanctions, especially in freezing some assets and limiting rights of some companies. There were also restrictions for the use of intellectual rights, as well as limiting the contact between the intellectual property agencies. This is just a brief overview of what was adopted. This started in 2014. The EU sanctioned Russia. They froze several assets. They published a list of natural persons and legal persons, even a list of intellectual property assets. These were some of the limitations in terms of breaking contact between intellectual property rights agencies. These sanctions were adopted by European Russian agencies agencies against Russians, limiting Belarus and Eurasia and European agencies. I don't understand the rhetoric, because patents are normally, there are 8 states as a member of this agency, and there's also an experience with the United States. And in terms of the United States, in the heat of the sanctions applied in 2022, several intellectual property rights were revoked for Russian citizens. Why was that done by Americans? Because the United States, why did they do that? was not widely publicized because they understood the importance of the cooperation in the intellectual property laws. They revoked the sanctions, and that's why they decided to sort of tone down the level of the sanctions and minimize sanctions in this area. Also altering their approach, removing intellectual rights. But in 2014, now talking about the EU in this case, we didn't have a lot of limitations in this area. However, in 2024, the package number 14 from the EU sanctions severely restricted the rights to industrial intellectual property of several natural persons and legal persons in Russia. They no longer have the rights of asking for the protection of their objects of intellectual property, whether it is patents or even trademarks. We didn't take any responses because we considered that the intellectual property is about the distribution of know-how and technologies. We adopted some responses against the sanctions. I summarized them in this slide. It's being shown here, but we were very careful about this. In the start of our sanctions, our anti-sanction measures, we adopted a government determination that determined or established that to ensure the exit of companies from the Russian market, the government, without the permission of certain patent owners for non-friendly states, can be retransmitted to other people.
Then, in 2024, this measure was revoked, but we harmonized this with the conditions of international agreements, and we determined that the compensation would be paid even for no-friendly states, with the special conditions in a special account that only be released upon resolution of a government. In the context of sanctions, we determined a import scheme, a parallel import scheme. For us, juries, it's a exhaustion of rights. In Russia, at the time of that sanctions were being applied against Russia, the national regime of that prohibits parallel imports, except for 5 countries, which are part of the Euro-Asian Union. It was created in 2014 when agreement. Since then, we are suffering the lack of some products in Russian markets, and our government adopts measures releasing the parallel importation. We have a list of products that can be imported by side. We adopted this part. Is the only example that followed this way. That was our decision, the official position of our government, the Ministry of Industry and Commerce, and now we are trying to reduce this list. We are offering exclusivity for the owners of patents and representatives of countries, even no friendly countries. We moderate this list. A lot of products enter this list, and now we are reducing this list. Products that can be obtained in importation in parallel. It doesn't matter if we're friends that keep relationship with Russia or not. we highlight that we are not against the return of Western companies into Russian market, but probably we will create special rules for their return to Russian market. When we talk about uh, importation in parallel with some peculiarities that some companies could be against um, this parallel importation, but the products are still coming to Russian markets. But it's still the first steps in this direction. When companies at distance can limitate the activation of a product in another country. If I buy a Samsung smartphone from a country where Russia has a relationship, but when you get in Russia, the company can activate it by distance. It's not a mass practice. Some companies adopted it punctually, but they didn't increase it. A lot of companies that left the Russian market in 2022, for example, Louis Vuitton, Mott Hennessy, is still has the intellectual property in Russia, even with the sanctions. What does it mean? It means that the company does not want that this new, for example, the trademark LVMH, women must recognize it. The company doesn't want that this trademark is used by another company in the Russian territory. Probably the company wants to come back to the Russian market. We have this slide, which may seem very happy for Russian tourists. It's a class case. In the beginning of the sanctions in 2022, one of our courts I think that in Brazil, you know Peppa Pig. The owner who is British required that from the Russian court that it was a third-party product and was violated the trademark right with Peppa Pig. There were some cases. It was a store in the region of Kirov. It was selling it without a license. And the Kirov court ordered that as the company is from Great Britain and Great Britain adopted sanctions against Russia, the requirements, the British requirement are abuse of rights law, and they denied the repair. We understood since the beginning that there is a risk in the. We think that this decision was not based on the rules of law, and then the Superior Court revoked this decision, and then now the Russian court decided that we have a national system. We defend the foreign trademarks as the Russian trademarks. We don't have limitations. If it's a company, it doesn't matter if it's a company that keeps relationship with Russia or not, even if in the area of defense. We defend the foreign trademark, patents and trademarks. So we believe that is the correct position. We consider that intellectual property must be placed outside the sanction rhetoric. Our last slide, I would like to call your attention to some sentences that we always mention in all the meetings. I would like to talk about the development in the BRICS of this area, not only in the format create a strategy of intellectual property rights, harmonize our approach. We tourists must support initiatives in this area because this in this area of intellectual property, because it contemplates the participation of our agencies, and we can talk about copyrights, confidentiality of production. I think it's important to legal audit, increase integration in this area. So I think we should highlight the importance of the adoption of international principle of the use of the rights, which enables the importation of products worldwide. This practice of parallel importation is increasing worldwide, so it affects the defense of consumer rights. The parallel import is always on the original product. I won't mention everything, I just want to say that it's very important to adopt, to highlight a commercial tool about the parts in the law. We don't have the opportunity in Russia to have parts of the law to divide the copyright. We can share the profit, but not it lacks in our legislation. I would like to call your attention to this issue because it's related to circulation of these rights. That's everything I wanted to say. I would like to mention again that the area of intellectual property and innovation, it might be one of the main strategical areas for BRICS of our cultures and technological capacity. Thank you. Congratulations for your speech. I'll give the floor to Dr. Vladimir Lopatin, who is the president of the Committee of Intellectual Property in Russia. He is going to talk about the challenge for harmonization of regulation in the field of intellectual product and innovations and ways to solve them in the BRICS. How are you? Thank you. Please. Please, my presentation. I try to speak in Portuguese. I'd like to begin supporting the proposals that were debated in our forum. Support the practice of Brazil, which organized this forum, and languages for the BRICS countries. When we claim that English is it capable of replacing the mind, the soul of Miss Paula? No, it can't. English cannot replace all the pain that she suffered on decolonization. How can we understand and perceive all the Chinese language when speaking English, all the richness of Russian language? I propose to support and approve the proposal of the Brazilian organizers that all our forums, subsequent forums, will be in our native languages. Now, 80% of all the operations, mutual commerce, is paid in national currency because why would we need to use a foreign language? for civilization, the level of civilization. It's the main point of support for in the future. We can communicate in our future forums based on this practice. As you can see in my statute, it's a little bit bigger than what was said in the official program I've talked about before. We make the rules that do not exist in the world about the economy of intellectual property. I will talk about the economy of intellectual property. The patent is just a paper. What really matters is that we receive revenue. How we are going to receive this revenue? Well, we can in these problems. I would like to focus on these problems.
And I also want to use this opportunity and my position as the expert. During 6 years, in the annual meeting in the UN, where I report how to develop the economy of intellectual property. From this perspective, why don't they let us speak at other sessions? That was the final forum, and there's not going to be any more of them. And for me, it's unfortunate. But I hope that my conference will be heard here in Brazil, and it will be shared. What do I have to press? I represent the Intellectual Property Scientific Institute, which for 20 years, where it started trying to clarify why we have so many quantity of patents, and the trade and the commercialization of intellectual properties, and the revenue still leaves a lot to be desired. Our institute divided intellectual properties into life cycles. All of the data, as source of scientific progress, is done through research and development. So, how do you receive the profit of intellectual profit? We identified the technologies and divided them into 5 stages. So we ran tests on several companies, and through this technology, we were able to increase our revenue. This is, for example, we have a project of the Suhoi plane and other projects that have been being sold in the market. But this should have been a general practice sooner, and the declaration of the laws of the Russian government were published based on our paper. But that's not enough. So we published the rules. These are standards, and they will be national standards, and now they are shared by 8 countries. We propose to also create international standards, because the International Organization of the Intellectual Property Defense focuses on defending, but defending without any economic benefits doesn't mean anything. Patents without any revenue don't mean anything. It doesn't interest anybody. So we work with patents of copyrights, know-how, etc. So these norms enabled us to disseminate this approach of the strategy for developing intellectual property at a national and international level, and could be used for the development of the market of selling intellectual property. That is the objective that we try to find when we seek the defense. If there isn't any sale, we don't need to defend anything. So, when a patent stops working after 1 or 2 years, it becomes a public knowledge, and so we are giving money to our competitors, basically. That is why we published journals and magazines in 12 different areas. For example, legal, economics, business, AI, machine learning, computing, information technology, and we also invite you to participate in this exchange of experiences. We also organize an international forum, which used to be the SEI forum, but from 2023 onwards, it became a BRICS forum. We are thankful to the delegations of the BRICS countries in this year. 26 countries participated, 800 people in several different platforms, and it was called the Development of Innovation Based on Intellectual Property. Now we have a website of our International Foreign Affairs Ministry. We have our model. We thank Sergei Lavrov, our chancellor. We celebrated the 20th anniversary this year, and we received a thanking note from our chancellor, where he manifests the certainty that we will continue to cooperate with the BRICS countries and help the ministry to build relationships and increase the economic revenues from intellectual properties. From this perspective of economy and the standardization of the intellectual property, I created a UN report. One of the 17 speakers that were there, and I was declared an expert in this. What's interesting is that the UN heard and adopted in the last year, during their General Assembly, the position that the intellectual property isn't a patent, but immaterial assets which generate added value and allow competition and ensure national sovereignty of developing countries, and they help to mitigate the inequality between the global north and global south. This position was supported in 2024, and in July this year, during the next General Assembly of Intellectual Property Law, it was declared as an financial asset. In Rio de Janeiro, we have a financial banking market of funds, and intellectual property is used as a means to get credit and as a way to ensure to issue papers. No, right? We declared this issue, and the UN supported that. This could be a way to reduce the economic inequalities between developed and developing countries, and between the North and the South and the globe. With regards to that, when we look at these figures, we can check that we are right when we say that the immaterial assets are growing much faster than material assets. $80 trillion from last year, which is more that value of the world's leading economies. Over the past 15 years, investment is 4 times larger than intangible assets. And why don't we then use these mechanisms? Why isn't it working in our case? Well, there is the question. I have said this before, that it's 135 goals, SDGs, in the UN, among which only 18% or 17% have reached a certain level of forecast and 35 are delayed. And why do some work and others don't? Well, when we model a situation at a partnership level in the BRICS countries and in the South, in the global South, there's another paradox. I got here 2 UN indexes. One is called the Human Development Index, HDI, which is considered in terms of the development of the education and sustainable development until 2030. In this index, the BRICS countries have range from 0.7 until 1. This is a high-level index. We are smart. All the BRICS countries are smart. But when we talk about the innovation BRICS, which means what do we make with our intelligence? The average is only 29%, which is a third of 100. Possible. And why is that? Because we're smart but poor. And then when we try to understand this, the situation is revealed as follows. I've been saying this for 6 years in the UN, and as I've been speaking this at a national and intergovernmental level too. When the countries like Brazil or Russia and India and China, which is a little bit sort of detached in this situation because they don't necessarily follow these rules. We are judged by 3 indicators. First, number of publications. In Western companies, general, like Web and Science, so on and so forth, and patents. According to these indexes, if we're leading these indicators, we get good grades. But what economy is in this sector? These indicators in 154 countries in the world accumulate in the last 8 years, are accumulated among 8 countries. And you know what countries they are, right? It's not our countries. We publish. A patent is a publication. We talk about our technical solutions to problems that we don't necessarily intend to defend abroad because it's really expensive, going even over the artificial barriers that we typically face. So this is the information about our achievements and the scientific and technical solutions we've been able to propose. It is accumulated into the 8 largest economies. What do? They produce these technologies, they sell them to us based on our knowledge and our expertise and our solutions. And these solutions, I think that 50% of their exports, and they keep 60% of the publications, 80% of the patents, and they ensure their GDP on our effort and our work because of our economy of knowledge. We ensure free access to information to our competitors, and then we try to understand why we have such a huge dependency on imports. What is really necessary? Well, to say no to these indicators and move to economic indicators. These are immaterial assets, and that's what was discussed in the UN. The creation of added value from the amortization of these patents. If we can consider the circulation of immaterial assets, if this doesn't exist, the authors won't receive payments, they won't have return on investments, and sort of there will be no balance, and we're not going to be able to promote innovative development in our countries, something that we've been discussed for several years. So if we observe our institute in the last 3 years, we had a analytical report about the BRICS plus countries. Since 2023, we have the same report on the BRICS countries. we can see that except for China, we have nothing to brag about. Since this is a legal forum, I'm going to mention one index here. And this is the level of regulation equality for the intellectual property field. We can see a small growth in India and a huge growth in Brazil. Brazil and Russia, unfortunately, alongside with South Africa, were way down there. Why? Well, some experts have analyzed the quality of our regulation in our countries, which are a third below what it used to be in 2023. What happened? Well, maybe it is a certain bias from the experts that belong to Switzerland Institute, or is it something else? I don't know. We need to analyze. I'm going to mention an example here that we had with the United States. Every year, the Department of the United States, based on a company, a private company, makes a list of 301 forged or falsified projects. They create a rating and adopt sanctions against countries.
They are means of competence, of bad faith competence, or the honors of American trademarks in our country. It's methodology you use to determine that a country beats better than others the falsified technology. It's a politicizing instrument to achieve economic goals. I'm talking about the United States. It was in 2012. We took the make decision of determine the level of falsification of products in the regional level. This standard was approved and adopted, is used by the countries of our customs union when our regulation got worsened. We are going to create a working group, understand the reasons, and give an answer. But we cannot stay silent when we receive this type of accusation, because in a politicized way, we receive some kind of we receive a negative opinion. We have to fight against it. Considering the new members of BRICS, +5, BRICS Plus, Indonesia, the level of differentiation in the issues regarding intellectual property, it increased. It got more diversified. The experience of one should be studied, supported, so this experience can be accessed by other countries. China in the 90s also was in the same level as China regarding intellectual property. What was made in China? They started to take foreign technology and to improve the production in the domestic market. When they were questioned, you are using the technology of others, the answer was always the same. We are exporting these products into your market. We are supplying the domestic market. From 1990 to 2010, the patents stopped to have effect, so the foreign patents that were adopted in a not very legal way by the Chinese organization, they lost their values. And China during this time increased the internal market, improved the technologies, and it started to patent in the other countries, the other markets. Using the international law, China could have its own patents, its own products in the abroad, which were initially based on third-party technologies. In 2013, I was invited by Chinese experts for a summit in Beijing, a summit of ministers of finance and banks. I was the moderator. I presented in the plenary of this summit as a financial asset. You can issue the issuance of bonds in the financial markets. 10 years later, my presentation was published in different Russian news journals. What happened 10 years later? Last year, China surpassed the United States in the area of intellectual property use as a guarantee of credit. In China, 15,000 organizations received credit with guarantees of intellectual property values. It's happening in Russia now, and we can use as a guarantee of credit the intellectual property, because banks are entering as investors in the projects of intellectual property for those who didn't have the funds to develop. Nowadays, we are doing pilot projects in this area to develop and obtain government support. This year, the president of Russia, Vladimir Putin, when he was discussing the economic forum in St. Petersburg, he ordered the development of the intellectual property markets to offer credits in this kind of property. Then, the president of the government, the president of the central bank, with other governors of Russia, from October 1st, 2025, they delegated that they should increase the credit this year. It has government support, and our institute prepared the patterns that are being used nowadays in Russia. Why this practice can be adopted in other BRICS countries? It can. That's why using China experience that they adopt means in a fast and dynamic way. I would like that we could have this this velocity. It should be what should be regulated when we talk about regulation in this area. Intellectual property, we have 3 areas: defense, with national codes, and economy. Our analysis showed that regulation is not well developed. Our legislators working more on defense. Our university, they look to promote development in the defense area, but they don't promote the market in economy. Our institute developed a course in our economic university in the first program of the master degrees. It's now being used in other countries about marketing and sales of intellectual property, assessment, sales, and marketing. Everything that we don't have in our marketing, in our education services. The proposals that we had, if we talk about strategy, it should be a strategy guided to the market not for defense. Talking about protection and commerce, we understand that we have the sale of products and services and sale of rights for objects of intellectual property which are used in finances and services. They have their values and the pricing, a very specific pricing. We talked earlier about development, sustainable development, and this is the same topic. Intellectual property, it should be determined. This topic is very complex. It requires a joint approach. If we talk about intellectual property, we have 20 types of this right. 10 of them are about property. They are subject to commerce and evaluation, sales and evaluation. And when we talk about regulation, we should understand that besides sales, we understand how to sell it. So we prepare different methods. We have 8 today. We are preparing the 9th. The first one in the world, the sale of assets, digital assets. With the guarantee of intellectual property, it could be interest for all the countries. If the UN is interested in our experience, it might be interesting for BRICS countries. Here we have the standards, which we have to be united. We create an international committee. In this committee of standards, the ISO, the Intellectual Property Committee. If we want our national interests to be considered in this market, we have to participate in the preparation of these standards and rules. By creating this committee, we'd like that all BRICS countries could participate so we could prepare together for the global community. We are 20 countries. We are the majority, global majority. We are the majority in population and domestic product. We should work. They should hear us if we work together for the interest of everyone. The proposals. Our final document. We hope it's supported. In the product known of this proposal were included. A work group was created in Johannesburg about intellectual property. It had 10 countries. Nowadays we have 11. I would like to ask that other countries could unite to this group. We could add intellectual property regarding sustainable development of the United Nations and our rules in the BRICS and create an international committee. To conclude my presentation, I propose I am a poetry. My friends always tell me that I should be more humble. What's the advantage? Lenin, his complete work has 55 volumes. I have on science and poetry. I published my 3rd book of poems. My 3 books: To Dream, to Create, To Love, to Create, and to Live. I showed you to some colleagues yesterday, and they told me that Rio is a very creative city. And I told them that the next book that I will release will be about Rio de Janeiro. this wonderful beach in Brazil. And I think that I started in 2 days. I wrote three poetries, and I would like to read it. I hope that everyone can understand with the translators about Rio de Janeiro.
Одновременно я хотел бы поблагодарить
Firstly, I'd like to thank our organizer and our translators who helped us to understand. I know that literary translation is a little harder than translating into a forum, but I hope, they are able to capture and translate things that I say. It is called Copacabana. The ocean sends its greetings every day. And the waves wash the margins of the city, and when the night comes and the city sleeps, the Atlantic Ocean makes noise, filling the world with life. From a fisherman's village, a 4-kilometer bridge erodes. Copacabana is art for everyone, culture, culinary, vanguard, and retro at the same time. 5 city halls, 170 kiosks, services, football, volley, and everywhere sports. The teams are able to fill themselves, and at night, the gastronomical sidewalk will shine with fireworks and play samba music, trying to expect carnival. The night comes, everybody goes out to the beach. They go to their hotels, favelas, and homes. And only Christ is left, extending his hands with love and bringing calm and peace. Yeah, so let's do everything in the same spirit, if you like it. I would like to thank. It's very beautiful and inspiring. So Rio de Janeiro is beautiful. So I'm happy we were able to inspire Dr. Vladimir Lopatin here. Now we're going to take a 15-minute break in the hall, and in 15 minutes we'll come back to read the Rio de Janeiro letter. Thank you very much, everyone.
Если кто заинтересовался, я надеюсь, что было интересно и будет дальше вопросами интеллектуальной собственности, здесь информация.
Bom, eu já posso falar boa noite, né? Pelo adiantado da hora. Good evening, everyone. I'll speak a little bit in Portuguese and in English as well, so everybody can understand me. I just would like to ask the countries the floor to take the seats, sorry, on the stage, please. All the members, including Cuba, everybody. E peço aos nossos colegas que
I ask our colleagues to take their seats.
promise there's going to be a very short closing ceremony. In every BRICS legal forum, we usually have a short speech from the delegates and also the exchange of gifts, which is a very traditional part of the forum. So where we celebrate our friendship, the relations between our countries, and our cooperation. So let's take the seat here on the stage, please, everybody, so we can start. And I'll ask each one to give a speech here, and let's move on. Okay, my friends, so we are going to follow the original order of the BRICS acronym. So E is from Brazil, it's the first one, so, and also Brazil is hosting the 10th BRICS Legal Forum. I'd just like to say to all of you that it is a pleasure again to host all our BRICS friends, so our very important nations, and it's a very important group. Ethiopia, please. Theodorus. Take the seat here. We cannot start without you. Ana, tem mais alguma cadeira? Não sei se... Tá. Depois eu vou... Senão eu fico... Enfim. A gente fica de qualquer jeito. Okay. Now we can start. I'd like to thank again every country. We know that some travels... But I think all of them are very far, so it's an effort to come to Brazil. So we thank very much for all of you, and also for the countries who have Italy participating also, who have other countries attending. So to all of our friends, it's a very pleasure for us, for the Brazilian Bar Association, to host you in Rio de Janeiro for the second time. So our first time, as I spoke in the opening ceremony, was in 2019, and now we are very happy to host you again. So in the closing ceremony, you have the speeches from the countries and also the exchange of gifts. So on the behalf of President Beto Simonetti from the Federal Council of the Brazilian Bar Association, I'd like to thank you very much. And following the order of the acronym, I'd like to invite Russia to give the closing speech. Thank you so much.
Добрый вечер.
Ladies and gentlemen, we are discussing the final conclusions, and what I would like to highlight that during these last 2 days, we participated with over 200 people from Russia, and Russia was represented in all the sessions from all the litigation, from technology, access to justice, and legal education. I'm very happy to see all of the members here. We have an exchange in June of a certain year with the participation of BRICS partners. We also had an exchange of opinions of how to lower criminality, to guarantee the safety of the populations in all the countries. We also discussed criminal courts and the practices to apply international standards. We also held a bit of work in the intellectual property rights. Our delegation also participated with our director, Vladimir Lepetin, with regards to the business side and the companies, the private companies in this private sector offering services of legal counseling. They continue to be important, and they help to guarantee the good process of national businesses. Jurist teams continue to work with, which allowed the continuous prospering of the businesses. Our idea to reform the legal education and also manifest that we're always participating, creating new laws, and we always follow up on everything happens in our society, considering that our countries have a lot of shared values and common principles. The cooperation in the legal area is done based on respect and trust, and we hope that the agreements manifested in the final declaration should be performed successfully. So I'd like to invite all of the participants to the St. Petersburg Legal Forum, which will take place at the end of June of 2026. So it's the cultural capital of Russia, and the Russian Bar Association is organizing this forum.
We'll be happy to help you in the participation of all the attendees. I want to thank the colleagues from India, China, Emirates that participate in the forum May this year. The main partner of this year was the Ministry of Justice of the United Arab Emirates. They visited St. Petersburg, and they were happy with the work performed in the forum. To conclude, on my behalf and of the Association of Jurists of Russia, I would like to thank the Bar Association for the hospitality and the performance of the to hold such an event. The weather was great. Next week they told me it will rain, so we could enjoy it. Muito obrigada.
For the St. Petersburg International Legal Forum. I have attended this event in 2019. It was amazing. So I recommend everybody to visit St. Petersburg, this amazing city, and an amazing event as well. So now, following the order, I'd like to invite India, please.
Thank you, Bruno, and bravo, Bruno. Really, the entire load and pressure you have taken for this event, I think tomorrow you are not going to swim, you are going to float in the pool. So thanks a lot for all the wonderful hospitality which OAB has provided. I think this is one of the most successful BRICS Legal Forum in recent years. And Rio is a place where, if you can make it, it's a dream destination. And as they say, if you want to have a reward, a sweet reward, you have to work for it. So for us to travel long distance has been entirely worth, not merely because of Rio, your wonderful hospitality, but also the kind of community and very intensive exchange of ideas and knowledge which we all could immerse ourselves in here in these 2 days. And one of my big satisfactions is that Rio has brought us very close to certain practical objectives which we were working on. And we have taken the steps. We are going to sign a declaration, and that declaration includes the broad frame of the BRICS arbitration network, its foundational rules and structure. And I think that is going to be a very concrete outcome of the 10 years in 10 forums we have devoted. So for me personally, it's a big matter of satisfaction and accomplishment. Next year, we are going to host the forum in India. And when you come to India, make an extended program so that you can visit places, savor the culture, and also the food. An important aspect about India is when you come, you forget about your routine of watching your weight. India will serenade you with food. We have full meals all 3 times a day. So you have to forget about watching your weight, calories, and also the fat content, because our best dishes are made with a lot of butter. But we will have other options also. And we will also organize a trip to some significant cultural monuments around Delhi. So that's why my request is to not just come for 2 days forum, at least make 4 to 5 days program so that you can take part in tourism and the forum as well. So with these words, I hope to see all of you in India next year, and it will be the 11th forum, and we will be having many other things in place. Many of us say it has been late, we have been very slow in accomplishing things. But 11th forum, 11th hour, but at least we'll have something which we aspire to. Thank you very much.
Obrigado, Prashant. Eu vou fazer um agradecimento também em português.
Thank you very much. I will thank you in Portuguese. When the speaker said bravo, I have to thank the entire team of the Bar Association, Brazilian Bar Association. It's not only a person, not one, two, three. It's not 1, 2, 3 persons. It's a very big team behind. I would like to thank Ana Helena, Kaique, João Paulo, Aline, Fran, everyone the Bar Association. We speak every day. We don't have time to go to bed. We work a lot. I want to thank for all your efforts to make it happen. Thank the translators, everyone that helped to build this event that has been built in the last 6 months or more. What you're seeing today is the result of a work of almost 1 year. Thank you.
Further, I would like to invite China to deliver the speech. Thank you.
尊敬的金砖国家各代表团团长、女士们、先生们、朋友们，大家下午好。经过2天紧张而充实的议程，第10届金砖国
Beto Simonetti, ladies and gentlemen, tonight I'm representing China. After 2 days of intense agenda on the 10th Forum of BRICS countries, we are to finish it. On behalf of the Chinese society, I want to say how happy I am for the hosting society, the Brazilian Bar Association, and all the poetry in Chinese say, although the path is long, we step in the snow to find each other. We have a lot of friends in Brazil, India, Russia, South Africa, Saudi Arabia, Egypt, UAE. Together we debated how the legal and academic board could, with the help of the law, protect the global governance, strengthen this global south, and develop the high quality of BRICS cooperation. First, the representatives of the countries consolidated consensus performing through the law force a high quality cooperation in the BRICS. A mechanism of cooperation of BRICS is an essential platform for collaboration of the developing countries. The representatives of BRICS countries can collaborate with the promote of the global south and promote a governance and inclusive and sustainable governance. With the exchange in the new international context, they draw a plan for the rule of law in the countries of BRICS. The academic of BRICS should get together with the multilateralism and use the legal tools to participate in the force of the global governance and the mutual gain to protect the international trade and the place of development of the BRICS country, all the emerging markets. In the international judges, as we discussed it in the relevant issues for the BRICS countries, this forum had important topics. We approached 6 topics in investment, foreign investments, resolution, disputes, technology, and access to justice, education, legal education, and protection of prosperity and intellectual property. The representatives of other countries expressed their ideas and presented constructive ideas for the next steps of the legal cooperation of BRICS countries. Third, we reached concrete results, the Declaration of Rio de Janeiro. The importance of legal cooperation of BRICS is increasingly evident as the common goal of the BRICS communities. We have reasons to believe that the results of this forum will serve as in a more direct and effective way of governance aspects of the BRICS and promoting the rule of law and the sustainable development of the countries of the group. The Declaration of Rio de Janeiro reaffirmed the necessity to establish an international order, multilateral and fair, and compromises the communities of BRICS to strengthen the rule of law as the basis for the sustainable development. There are prioritary areas for the mechanism of cooperation and network arbitration networks and collaboration and organization, international collaboration and organization. The Chinese society, the law Chinese society has always, we want together with our colleagues from other countries to increase the fields of cooperation to surpass the barriers and regulatory, and it's a challenge with practical actions and dominating the productivity of cooperation and circle of consensus and a new force for the development. In the Declaration of Brasilia in Rio de Janeiro,
The 10th edition of the forum has passed the torch of legal cooperation, gathering significant results after years of good performance. Together, we have witnessed the firm advancement of legal cooperation of the BRICS for the creation of a consensus and principles, as well as the concrete implementation. And we've also seen the power of cooperation between countries that don't have borders. And we also preserved the legal spirits of multilateralism. So currently, the changes in the world without any precedents are accelerating the slowly recovering the economy, and the governance, global governance system has gone through severe transformations. The more turbulent, the more we need to be together. And China is ready to work side by side with the BRICS countries to build a more prosperous future and a brilliant legal cooperation, contributing with more knowledge and force of the BRICS. I once again would like to express my thanks to the Brazilian Bar Association, and I hope that I am able to see you in the next year. Thank you.
South Africa, for the closing speech, please.
Bruno, my friend, to you and the team, receive our gracious gratitude from the Law Society of South Africa, Nadel, President, and your executive, the bar in South Africa of the advocates as represented here by Advocate Badela. We thank you so much for your hospitality. We have expressed yesterday when we arrived to your president that his hospitality was somewhat exceeding the room, and indeed we felt it over the past 2 days. To all colleagues of member states of the BRICS Legal Forum and BRICS Plus and its partners, we appreciate the fact that BRICS Legal Forum gives us an opportunity to appreciate the work of lawyers across borders. It gives us an opportunity to understand at least the human face of the law that we seek to ensure that we protect the marginalized, we protect the vulnerable, and we use that law as an instrument to equate the unequals. And if we can continue doing that, then there is much more we can benefit from it. As we head for the close, the one lesson South Africans are taking from this space is that indeed we are more important as lawyers across the divide, both racially and culturally and otherwise. We are more powerful beyond measure because we are able to assist our respective governments and citizens to coexist without one trampling over the other. And as we develop all these rules to regulate our own conduct and the ethical conduct of lawyers, and also the ethical conduct of businesses being carried out in our respective countries, we are able to take responsibility for that which we have to produce. We are more energized to meet in India next year, Mr. Kumar. And we hope that the lesson you would have learned is that Brazil was able to transcend the agenda of Russia and be able to come up with a theme that is able to address at least the next stage as we go along. Can we then take this as a lesson learned so that as we host others after the Brazil, the Rio conference, we do so with a view to improve on our service provision for all of us. And as we leave, we thank you again, the Brazilians, for being such a good host. We have learned our lessons. We have obtained adequate knowledge, and as a result, we plan to be able to plow back into our communities and the legal fraternity in our countries. We are more strengthened by the fact that there is so much expertise that seemed to transcend the conversation in the room. BRICS countries have so much knowledge that we must stop complaining. We must start using the expertise that we are able to show that we do have. All the panelists that came here reflected a center of knowledge that we cannot in any way undermine and or think less about. So if we can, at least on the basis of the existence of the knowledge base that we were able to expose to ourselves, take lessons to say, how best does then BRICS Legal Forum becomes the catalyst for the changes we want to see, so that we stop complaining about others and be able to develop measures to counter any other intent to frustrate any of the countries in the BRICS Legal Forum and any of the countries in BRICS itself. Then we will be able to be achieving something. With that said, thank you so much for being so collegial. Thank you so much for being so educationally inclined. And thank you so much for being such a wonderful host. To you and the team, we can't thank you enough. We know very well that that was just a mammoth task that you pulled through. Nelson Mandela says in closing, it always looks impossible until you have done it. So keep thinking that way. Thank you.
Thank you so much. Now I would like to give the floor to UAE, please. Now it's a random order, so.
Hi, good evening, everybody. It was little hard and very stressed when we are traveling from United Arab Emirates, even other parties from China, Russia, India. We are taking long distance to reach here. It was our dream to reach Brazil and especially Rio de Janeiro, but by our friend Mr. Bruno, we implement our dream. Secondly, related to the BRICS Forum or BRICS Plus Legal Forum, UAE delegate, this is the second year, which is we are just a junior, but we learn a lot from our colleagues here. So we will not add more points what our colleague was saying, but we will move forward, and we are trying to have something very good for everybody. And I will just mention one very important point for myself. Maybe nobody will recognize that. Thank you, Mr. Bruno. I congratulate you for selecting closing of this forum today, because it's distinguished number 25-10-25. Thank you for everybody.
Thank you, my friend. Now I'd like to invite our colleagues from Iran to take the floor, please.
Oh, merciful God. Good afternoon, distinguished presidents of delegations, colleagues, ladies and gentlemen. Years ago, Blaise Pascal said, cordiality is more than everything that's fair is just, and everything that's just is fair and strong. However, in the world of today, greed of the powerful is human weakness that led the power to become the meaning of injustice, and powerful men are considered fair, which opened the path for the domination of the powers and deviating us from the path of justice. Now, the legal BRICS 2025 legal forum is reaching its end, and it should declare in unison that the world needs justice and not domination, meaning law, not sanctions, solidarity, and not isolation. In this summit, we will be based on the principles of respect to the UN letter, as well as a basic document for international law, denying the legitimacy of economic sanctions and coercive actions against the Article 2, Paragraph 4 of the letter and the Resolution 2131 from the General Assembly, supporting the right of the nations to develop and determine their own paths, as well as reinform the Security Council of the UN to end the global decision-making. The BRICS Summit has demonstrated once again that attorneys can be the voice of justice beyond borders, based on the principles of the Universal Human Rights Declaration 1948 and the Pacts in 1988. We believe that humans, regardless of nationality or religion, deserve to have peace, dignity, and safety and security. I once again would like from this pedestal to say that the crimes committed against the Gaza people and the military assault against the Islamic Republic of Iran are clear examples of crimes against humanity. And we have that this 7th article of the Rome Statute, and the lawyers of BRICS have the power to act document and coordinate the global illegality instead of remaining silent. Yes, the individuals should consider justice as power, the justice legalists as strength, but because of their weakness, they don't do this. They do the other way around. The most important objective we can reach, the service of justice, the men and women that are making history in the legal forum of BRICS, would be to give back the truth and the justice to its main path, and to build capacities in the arms of justice in order to reach the rights of its members and other oppressed peoples throughout the world. In the name of the major great nation of Iran and the Iranian Bar Association, I would like to thank you all for your efforts towards global justice. May the light of wisdom and courage shine for us to create a world where law is superior to power and humanity overcomes polity. Thank you very much for your attention. Have a good night.
Thank you very much. Now I'd like to give the floor to Ethiopia, please. Teodros.
Thank you. Thank you very much, Bruno. So, good evening, everyone. Olá, pessoal. I'm trying to improve my Portuguese. So, in the past 2 days, we have accomplished a lot. The successful meetings were deliberated on so many important matters, and also glorious opening that brings so many senior figures. Also our networking events, the discussions were all impactful, so we're very glad. So tonight it's a time to celebrate all this, and allow me to extend my heartfelt gratitude on behalf of myself and the Ethiopian Federal Bar Association, for everyone who took part in this conference, and every single contribution that was a key factor for our success. Ethiopia, joining the BRICS, we believe that will make an addition for the bloc. That will be an important addition. Together we'll be stronger. Together we will flourish. Our admission to this esteemed society is not just a milestone for our national bar, but a testament to the collective strength and unity of the legal profession around the globe. It marks the beginning of a new chapter where we come together, united by common purpose, to uphold justice and principles of the law that form the bedrock of our societies. I would like to take this opportunity to express my gratitude to our Brazilian counterparts for their unwavering commitment in fostering collaboration and also professional excellence. Your dedication has created a platform where we can share knowledge, exchange ideas, and building lasting partnership that transcend the borders. And thank you for that. And to my fellow presidents, national bar presidents, continental leaders, your leadership and vision have been instrumental in shaping the path forward. Together, we have the power to influence policy, advocate for reform, and uphold the integrity of our legal systems. As of now, I want to announce that the Pan-African Lawyers Union, which is a membership of 54 national bar associations and 5 regional organs, which includes SADCLA, which we have the president here, ALS, WAMU, the Northern African Bloc and the Central African Bloc, together with the 54 bar associations, will now have a formal partnership with the BRICS Legal Forum. And we are going to start that with an MOU that will be signed today. So it will be not only instrumental, but also symbolic for the future of this specific platform. Yeah. Of course, I see BRICS Legal Forum has to grow in many ways. In terms of initial capacity, in terms of internal operation, mutual understanding and respect, professionalism, we have to work a lot to make this platform better so that others will be eager to join. Others will see it as a very important platform to exchange ideas, to share experiences, to support each other. So in conclusion, I'm filled with hope and excitement for the future of our respective continents. Let us continue to stand together, committed to the principles of justice, equality, and rule of law. Together, we can overcome any obstacle and build a brighter future for the future of our region. Finally, my special thanks goes to Dr. Bruno for your exceptional hospitality, also the president of the Brazilian Bar, of course for Anna, which has been supporting us. Thank you very much. And the entire team, I cannot call your names, but thank you very much. It has been a very special experience that we have in this beautiful coastal city of Rio. And also Chami as well. She has been always there. Where is Chami? Yes. Thank you very much. Thank you very much. So I'm thanking all of them for their continued efforts to make this happen, and all the council members and everyone in this conference for their warm and exceptional reception. I'm humbled. Thank you very much. Obrigado.
Thank you so much. And now, my friend Mohammed from Egypt, please.
Thank you, Bruno, for always counting on me to make people awake. Okay. Ladies and gentlemen, distinguished colleague, as we reach the end of this remarkable gathering, I wish to express my heartfelt gratitude to our hosting country and the hosting Brazilian Bar Association for their generosity, vision, and amicable organization. You have not only welcomed us with professionalism, but with warmth, and that makes all the difference. Over the past days, we have exchanged words, ideas, and perspectives, but now comes the real challenge to transform those words into actions. Let us return to our nations not only with documents and resolutions, but with renewed purposes, to build networks, create support hubs, and strengthen cooperation among our legal communities. Together, we are more than representatives of our countries. We are builders of a shared legal future. We are builders of a shared legal future rooted in justice, equality, and solidarity. The BRICS Legal Forum is not only just a platform for dialogue. It is a living space where friendship, trust, and commitment are shaped. So let us keep the spirit of this forum alive. through every case we handle, every reform we advocate, and every young lawyer we inspire. Thank you all, and may our collaboration continue to grow from words to actions, from ideas to impact, and from today's discussion to tomorrow's achievements. Please, go back to your children and family, inspire them and tell them that we have been part of the coming future, 2050. Thank you all.
Thank you so much. And now, the closing speech from Cuba, por favor.
Buenas noches, colegas y amigos.
Temos abordados nesse fórum of perfectioning work of BRICS, and we have the desire and the need of the collaboration, integration of all the countries, which prevail the justice, the equality, and the social inclusion. And intention of that to lead us to affirm a phrase that expressed was the history of the revolution of Fidel Castro. A better world is possible. We want to thank you, the organizer of the event, for the warmth that we've been treated, the quality of the speech, and the quality of this event that was for us a very significant. Acknowledgement, a special acknowledgement on behalf of the Cubans and the name to our dear Ana Elena and the Brazilian Bar Association that allowed us to participate here, that will have the better experience because of the quality of the talks and the speeches that were offered.
So I'm now declare the end of the 10th BRICS Legal Forum. I just would like to ask all the presidents to stay here on the stage. So we're going to take a photo together, okay? So I think you can stand up for the photo, please. Very traditional in the BRICS, especially in the last photo. So everybody give hands and do like this, okay? So a traditional way. Now we're going to exchange our gifts. Just, eu vou falar, eu não sei mais nem que língua que eu.
I don't even know what language I'll speak anymore, but anyway.
Disclaimer from Brazil, we gave the gifts before, during the opening ceremony, so I think... So we gave all the gifts before, so Brazil won't give the gifts now, so thank you.